important to mention, land acquisition compensation matter and not in disperse the amount. 10 years has gone by.
In the list item, weekly list item 127, upgradation of a post in the establishment of the High Court. Your Lordship, I had it, but asked me to submit a note. It can be taken up tomorrow in the supplementary list.
File your note, we'll see that. File your note if there was a direction. Yes,
pardon to mention, matter out of the list, my lords. Without notice under the Securitization Act, my lords, they have directly published the auction sale notice, which is scheduled to be. It was published just 3 days back, and they are scheduling it to be, auction on. I think they are.
Will be a alternative remedy we are.
My lords, without it, they have not followed the entire procedure. Let it come up before your lordships are satisfied.
Please give them memo.
Yes.
My lord, I may be pardoned to make a mention. It's a challenging the vacation notice under Securitization Act, my lord. When the matter is under sub judice DRT, the bank obtained the 30 days going to expire unless the matter may be taken tomorrow, my lord.
Please.
They will vacate my properties.
I may mention, my lord, the Auckland is in jail and about 10 years. It comes to
9 the weekly list. Kali thila achi si any supplementary list asking
9.
Item 9 in the weekly
will be taken up. Why are you mentioned?
I may be fine. Item 92 in the weekly list may be taken up for, I think the may be taken up this week. Let's see, the urgency is there. They all the other except me, all the other persons are regularized. They
Yes.
only
Item
1. There is a batch of cases. Out of 6 cases, 4 matters are fresh admissions. So, my lord, I let it come as fresh admission on 23rd, my lord. Being placed, second matter may be placed at the first in the top of the list. Item 201.
Item number 31 of weekly list. May I pray, I may be permitted to withdraw the proposition for final declaration.
31 withdraw.
For final liberty.
22382 of 24.
22382.
All right. Yes.
Pardon to mention, my lord, land acquisition matter.
Liberty may be fine. Given to
Liberty.
I am better late appeals.
All right.
supplementary list, item number 1.
Supplementary list will be taken up after the weekly list. This admission.
Weekly list, item number 29.
Yes. Yes, item 29.
Yes. And the petitioner the present with application challenge the annex 3
22.
at close 32. Challenge illegal, arbitrary, and terrorist the reproduction of the petitioner contrary to the direction of the Supreme Court made in the annual writ application. I have annexed the application. The petitioner approached the Supreme Court, and the Supreme Court, while disposing of my annual writ application, has directed the approved party number 2, that is at Annex 1 series, page 21.
Where is that earlier order? Where is the earlier order passed by this?
Annex page 23, Annex 1 series, page 23.
Yes.
The Supreme Court, taking into consideration my grievance
Yes.
regarding non-settlement of the land for the petitioner school, has directed the concluding paragraph at 5, page 24.
In court of opinion, counsel for the petition states and highlighting the grounds the petitioner made representation to the department to head annexed 5.
Yes.
And the same is directed to be considered within the stipulated time to whom the learned counsel for the state has no objection.
All right. So they have disposed your representation. Yeah.
But not the representation which has been reflected in the earlier order and annex 5. My annex 5, the earlier date application was relating to statement of land in progress in respect of alienation case number 37. But your lordship will find from annex 3 is 34. Plus 35 lordship alienation.
No, this that is your
Relevant is described order to alienation case that is 15 of 22 and 8 of 23.
so 37 has not been
Wells tradition. For which direction has been issued to the tradition.
that from me what that two numbers.
That is at page 34 lordship paragraph. Lordship but and whereas alienation case and the consular right to submitted report by letter number 50 dated 3/1/24 stating that the had filed form 1 of settlement of government land in favor of Gopalji government upper primary school on 28/7/22 in respect of plot number 178, 183 and 184 under Khata number 482. This plot is the matter of consideration in alienation case number 22. Thereafter, I am reading a similar proposal form one was also filed by the DO for settlement of the Withdrawal land in program after the I.S.Sahoo 19-22. No, in these alienation cases, the plot numbers are different. The plot numbers are different and that 37. Alienation case number 22 was to be considered. Was to be considered. Yes. Right. But the plot involved in alienation case number 37 yes. is not the one in 15 of 22. No.
Please come to that page number 23. See the your the first prayer.
Yes, madam.
The plot number has been given 184.
183.
Just a minute. Plot number 184. Area. A person 320 decimal. Then another plot is 183. That area is
that is 50 decimal.
50. All right, 50 decimal.
And plot number 178.
178. 40 decimal.
Khata number is 482.
Khata 483.
Yes.
483. So this
that which is the subject matter of alienation case number 37 of 23.
Okay. In this annexure 3,
yes, sir.
There is no reference to any of these numbers.
Reference to this number, but while this will be the page 35, annex 3, page 35. The report has discussed about the plot which has been mentioned in alienation case number 37, and whereas the social validity has submitted report by letter number 50 dated 3/1/24 stating that the BA validity had filed for 1A for settlement of government government upper primary school that is the business on 28/7/22 in respect of plot number 170, 183 and 180. Yes, under Khata 482 thereafter I am reading. Of mobile settlement, similar proposal form 1A was also filed by the DA for settlement of reduction land in Kola Artatana Vidyaniketan I.S.Sahoo on 1922. In the meantime, one plot, next paragraph, one plot having 470 of 1622 under Khata number 480 of Mega I.S.Sahoo has already been recorded in favor of Mutation government private school. Yes. It is also submitted that to settle the land in favor of the above named school, two separate alienation case That is Alienation Case 15/22 for settlement of 160 decimal in favor of Gopalji Government Primary School, and another Alienation Case number 8/23 for settlement of 21 decimal of land in favor of Arthakala Vidya Niketan. I shall have been processed and sent to sub-collector Bhubaneswar by letter number so-and-so, dated so-and-so, and later known as the copy of the report of the Tahsildar Vadmula is attached to it, and whereas the status of the above Alienation case has been examined in the district revenue section, and it is asked that the proposal processed by the Alienation case number 15/22 for settlement of 16 decimal of land out of plot number 458 under Khata number 408 have been kept such a law that major allocation in favor of school and mass education department has been submitted to government in reduced disaster management department rules against issue or punishment and for the planning member video against and the proposal land exists within the number also dated 29.
In respect of that,
Nine points to the court that this amendment has directed to dispose of the plots which are the subject matter of Alienation case number 37 of 22.
yes,
But what the collector did, while he demonstrated in the Annex 5 as per the direction of this report, as per the document report of the prosecutor, has taken up the thing that is Alienation case number 15 of 22 and 8 of 23, which is not the subject matter of Alienation case number.
how does it matter? Because your plot number involves the same.
No matter.
Yes,
No,
see your first paragraph. See the first paragraph of the order. The plot of the Orissa with a prayer to record government land bearing plot number 184 area 32, plot number 183 plot area 50, and plot number 178 area 4 decimal.
that paragraph is the contents to which I read in Alienation
Also on that.
But while the disposing and reproduction, the number has taken up to other two Alienation cases, that is 15 of 22 and 8 of 23,
But it
which relates different.
if those two cases relates to the same plot,
No, my lord, that is not different. It is different. What is different?
is what do you say, Mr. Vijay?
Maybe of some motor, but
The page 35,
Hmm.
second paragraph.
Hmm.
And whether the presentation of petition under Annex 5 is examined and found the petition in the chairman of local G government office school
Hmm.
submitted application along with copies required document that is RR transfer so and so. Plot number bearing 184, 183 and 173 area. After to the representation of the disposal.
those books not related to Alienation case number 37 of 22, which has been directed to be disposed of by the party, by the Supreme Court in the annual rate application.
Specifically କିଛି mention करना थी also. You are right that so far as those they say that other lands have already been recorded in your name, and in one case they have recommended it for the so you the land. There are three cases you have already proposed before the government. In two cases, government has already allowed.
One case, the government is allowed. Another is because of another school.
Your cases, Gopalji.
Neither is Gopalji.
Yes,
7 of 22, which was initiated by filing an
the page number 35 also indicates that plot number is 470 by 162.
162.
Number is 480. That has already been recorded in favor of your school.
It is recorded,
Right.
but the other three, you lost some time from the ROR. I have annexed. Can you have a glance to annex of this date?
What he wants, Mr. Party, suppose this particular alienation case is in respect of one, let us say A and B plot. Okay. So he should have mentioned whether A and B plot can be given to the school or not. That's all. He has stated that that is exactly he wants. Suppose it is that plot might have been given to somebody else, whether it is or it cannot be given to the school. Specifically, So school.
Those plots have been taken in favor of other schools. So how can they take? Anyway, a specific order was to be passed.
The petitioner, Gopalji Government Upper Primary School, represented through its chairperson, School Management Committee, has filed this petition with the following prayers, quote, Roman 1 and 2. Mr. Patnaik, learned counsel for the petitioner, submitted that earlier the petitioner approved this court in WPC number 28263 of 2023 with following prayers, quote that from paragraph number 23. And by order dated 30/8/2023, this court directed the opposite party number 2. Opposite party number 2 in that case was the collector.
Yes.
Okay. Opposite party number 2, that is collector cum district magistrate Khurda, to consider the representation filed by the petitioner
Dated 22-23. Yes, 59.
dated केते
22,
22
2023.
22/2023 সেটা
Yes.
page 54 and 5 is at page
And except 5 in the annual application was post 50. In the present rate application is post at page 54.
54.
Yes, ma'am.
अच्छा, this is dated 22/2023 ହେଲା
This is plot number annexure 3 and page 30. Page 30. Page 30. Auxiliary category lands. I'm return calculator.
decided that your level to verify
April next issue permission ତାପରେ PEO ଦେଲା ଏ ରିପୋର୍ଟରେ ଲେଖିଛି କଲେକ୍ଟର PEO ଦେଲା ଏଇଠି ଆସିଲା Block education officer and the Tahsildar Bari Department several times proposed government land has not been recorded in favor of Gopalji Government Upper Primary School as yet. It is according to Tahsildar Bari Department has submitted a report page 178, 183, 184 under category 4 of Moja alias and similar proposal in column number 1A was also filed by the DEO.
for settlement of the above settled land in favor of that's the company. Same process they are arranging specifically to be considered by the collector by the collector if it is in non-condemnation with that particular provision case or something. That's 30. 37. And pass appropriate order in accordance with law. It is the contention of the land counsel for the petitioner that without disposing of the alienation case, without disposing of the representation of the petitioner in connection with alienation case number 37
of
of 2021,
2022. Yes.
So that's 37 of 2023. 37 of 2023. The collector by annexure 3 has disposed of alienation case numbers. What are those two numbers? 15 of 2022. 15 for the
That is 22 and 8 of 23.
Alienation case number 8 of 2023 and 15 of
2022.
Page 35. Which are nowhere related to plot numbers 184, 183 and 178 under Khata number 483. And therefore, specific direction may be issued to the collector to dispose of alienation case number 37 of 2021 as per the previous order passed by this court in WPC number 282 of 28263 of 2023. The land counsel for the state placed the impugned order dated 6/3/2024 after going through the amendments taken in the writ petition. So also the earlier order passed by the court in WPC number so and so, and the impugned order dated so and so. We are of the view that there is no clear findings in the aforesaid order dated 6/3/2024 relating to the disposal of alienation case number, disposal of the representation in connection with alienation case number 37 of 2023, which are obviously related to plot number so and so under Khata number 483. But therefore, the collector should consider the representation. Our praise representation earlier, which have been filed earlier as observed by this court in the order dated 38/2023 with relation to alienation case number 37 of 2023. It is made clear that we have not expressed any opinion that the entitlement of the petitioner for alienation of the aforesaid plots in its name. Accordingly, this decision should be taken within a period of 3 months from the date of production of the certified copy of the order, and within 15 days the same should be communicated. If the collector feels it necessary, personal hearing can be given to the petitioner. With the aforesaid observation, the writ petition is disposed of. Yes.
Item 30.
Can you have a glass page number 42?
The representation disposed of 90, annexure 9 is the representation. 5/7/2024.
Minutes.
Annexure 9 to this. Yeah. Item number 3 is annexure 9 is to be.
Item number 32. Please, Your Lordship. Your Lordship, these are the similar cases that Your Lordship had dealt few days ago, Your Lordship. It is regarding the payment of the compensation for over the structures that was acquired during the foregoing. Yes, Your Lordship. Of a similar order. Your Lordship, only the first paragraph is not required since the cause title is corrected in the present writ petition, Your Lordship.
So you are appearing for
51. Actually, we do the NHI then.
have you sought a copy of the application on the there was a direction to the NHI. No, you should have sought copy. I think Amitabh Das is appearing. Mr. Das, who is appearing for NHI? Amitabh Das. You should have given a copy to me.
Lordship, copy was served, Your Lordship.
So ask him just to give a ring so that he can come, and in his presence we want to dispose it of. Mr. Das, just give a call to that. Just to him, we are passing it over. Yeah.
Oblige, Your Lordship.
Because ultimately the NHI is to dispose of it. So in his presence, we will pass it.
Item 33.
Regarding item number,
It is my lord, for good matter, my lord. Similar order on page 12. Annexed as Annex 4.
Similar order was passed. In Annexure 4.
My lord.
Similar order you want to
Similar.
Annexure 4 is similar. All right.
Item 34.
I have similar lordship had passed order for the initiation of arbitration under 3G. Item.
All right. Item number 16. List item 34.
Item number 35.
My lord's annexure 3 representation matters, same order.
Serial number weekly 34, 35. Yes.
Next is also condition annexure 4, but there is none. Annexure 4 is there for representation.
Because of the representation annexure 4. Yes, Lord.
Annexure 4 representation. Okay.
And the acquired by the railway, and the land has recorded in the name of the.
It's all right. They will consider it and communicate the order to you. 15 days. Yes.
Item 36.
Minor, our appearance will not take it. Yes. For Union of India. DK Party Mailer. Virendra Kumar Party Mailer. Virendra Kumar Party. Item number 36. 36 Mailer. Yes. Virendra Kumar Party. For Central Government Council. Yes. How like that?
Item 37.
Next. Password for the copy has not been served. Let them go. Let her come. Ask please to hand over the copy.
Item 38.
May I please also. My lord, the government of India has brought the guidelines for evacuation of some residents from the Tiger Sanctuary project. That is Annexure 2.
Annexure 9 is the representation.
Where the government of India with the protocol voluntary evacuation of people need to be done only in the identified core or critical tiger habitat in the tiger region.
What will be representation dated 4/7/24? Annexure 9.
Order. Under 108 page below. What happened?
No response has been received.
No response has been received.
Annexure. Yes. Yes. If not, would have a copy, Mr. Mishra was with on the state council. Copy
ଦେଇଥିଲେ ଆଉ ଯଦି କହିବେ ଦେଇଦେବେ
କାଲିକି ନବା ଗୋଟେ କପି ଦେଇ ଦିଅନ୍ତୁ ତ ଦେବେ ଆଉ
କାଲି ତ କି ନେବେ ସେ ଇନଷ୍ଟ୍ରକ୍ସନ ଦିଅନ୍ତୁ ସେ ଇନଷ୍ଟ୍ରକ୍ସନ ଦିଅନ୍ତୁ
give a copy
ଆଜ୍ଞା ଆଜ୍ଞା ଆଡଭାନ୍ସ କପି ଦେଇ
and council for the state OPSC को देवे OPSC को देवे ଗୋଟେ copy OPSC also a party OPSC OP number 2. What is your prayer in this application item?
prayer ଅଛି ଯେ ଆଜ୍ଞା ଖାଲି ମୋର ଯଦି ସେଇ ଭୁଲ କ୍ୱେଶ୍ଚିନ୍ ଗୁଡାକରେ ଯଦି ଠିକ ହେଇଯିବ ତାହେଲେ ମୁଁ ପାସ୍ କରିଯିବି I am not challenging the entire selection process.
So you have to give a copy to the land council for the state
as
well as OPSC ପାଇଁ କିଏ appear
Vijay Das.
Mahanti Vijay Das, President. Mahanti will be there. Mr. Mahanti will be there. Pradeep Mahanti. The land council for the petitioner shall serve a copy of the writ petition on the land council for the state. So also Mr. Pradeep Kumar Mahanti, land senior advocate who usually appears for opposite party number 2. Matter to be listed next week.
By tomorrow I will serve you. Item 39.
Yes, my lord. 13-4. 13-4, my lord. But one thing, my lord, the petition, the opposition of party number 4, who is the take the loan or auction purchaser, he also filed a writ petition this on the court, and that's also disposed of. Already, you will also go to answer 5, my lord, page 41. Page 41. He has filed a reputation for the branch manager to refund the amount. I also answer 6, my lord. I also filed a representation to the bank manager that we have settled the amount. We have no objection. The opposite party 4 also interest to take back the money, and I also interest to pay the amount money, my lord. So that now the 13-4 notice has been I am challenging what.
We have already sold even the property.
But we have not possession the property under the
land council for this one, so that the property has been already sold. This is 13-4 notice. Alternative remedy is available.
My lord, I have 3 months in the state status quo also. I
sorry. Go to that. Yes, next.
Item 30.
It's for another time.
No, Mr. Das can.
Mr. Das, which is that matter? Item number 32. Where is that, madam?
I am for the person, madam.
Acha. It would covered matter really goes in to देखिले से
Notification by the NHA, whether it is executed by NHA or state government, where there are two types of project. One project NHA itself is constructed some road, and
ଆପଣ କପି ଦେଇଥିଲେ ବୋଲି ସେ କହୁଛନ୍ତି ଏବଂ ସେ କହୁଛନ୍ତି ଏଇଟା କଭର୍ଡ ହବ ବୋଲି ୟା ଦ୍ୱାରା ସେଇଥିପାଇଁ ଆପଣଙ୍କୁ
order sorry.
ହଁ ସେଥିପାଇଁ ଆପଣ ଦେଖି ଦଉନାହାନ୍ତି ବସିକି ଦେଖନ୍ତୁ ଆମେ ଟିକେ ପରେ ନବା କଣ ଅଛି ହେଲା ତ after going through that you can come Mr. Das. After going through that, if you are satisfied that this order covers it's a similar matter, you can tell there is no problem.
Because it is stated by my friend, there is a dispute among the recorded tenants.
Yes, madam. They record.
3x4 sets of
We just want the representation to be disposed of. So that is all. The earlier order is also like that.
yes.
So we are not
Directed to.
My non friend has given me direction to give compensation.
no, that we cannot.
We direct the NHI to make
No.
steps for payment of compensation.
Some
Yes, for generation report and knowledge.
32 টা বার করুন।
If there are disputed,
No, we just see it. We are in this item number 32, the first matter. 22422 of 2024. So order টা দেখি কোন হয়েছে?
triple to double three order.
No, there the valuation report was already placed.
এটা কেমতি কভার
Different. It is completely different. That madam was.
madam.
Malad. I am here. This is different.
How it is covered already? This is completely different. As a valuation ହେଇଯାଇଥିଲା ତାପରେ ପେମେଣ୍ଟ ହଉନଥିଲା
ଖାଲି disbursement ହେଇନଥିଲା.
disbursement ହେଇନଥିଲା ବୋଲି ଆମେ କହିଥିଲୁ ଯେ as per the valuation report balance amount bill ତାକୁ disburse କର. How it is covered? It is disputed ଜିନିଷ ଗୁଡା.
Malad, annexure 4, kindly say annexure 4, Malad.
Please come to your prayer portion. Page number 10 of the writ petition.
Malad.
Prayer portion କୁ ଆସନ୍ତୁ.
Malad.
ପଢନ୍ତୁ ତ conviction.
It is therefore most prepared that this honorable court may be graciously pleased to pass a section of 1 and 2 to pay the compensation to the petitioner towards the structural cost of over plot number 1654P pertaining to Khata number 29 of Mauja Kolapani in the district of Bargarh, which has been acquired for the purpose of 4 laning Sambalpur Bargarh Odisha Chhattisgarh border section NS6 in the state of Odisha, and thereby be pleased to pass the general eviction notice by Director 6 manner.
So ଏଇ ଯୋଉ plot number ଟା ଆପଣଙ୍କର ବୋଲି କୋଉଠୁ ଆସିବ?
Annexure 4 ରେ ଆପଣ ନା list ଅଛି? ଆଜ୍ଞା. Annexure 4 କେତେ item number? Annexure 4 first item is my lord, that is Prabhu Kumar Gupta. First item ଟା କିଏ ଅଛି? Last case ରେ ଯୋଉଟା order ହେଇଥିଲା ସେଥିରେ ଗଙ୍ଗାଧର ଦାସଙ୍କର ନାଁଟା serial number 17 my lord. 17 ରେ ଥିଲା। ଆଜ୍ଞା। ଆପଣଙ୍କରଟା ଏବେ କୋଉଠି ଅଛି? ବର୍ତ୍ତମାନ ଏଇ ଯୋଉ ଫାଷ୍ଟ କେସ୍ ଭାଗ୍ୟବନ୍ତ ପୁଅ ଯୋଉଟା କୋଉଟା କାହିଁ ତା ବାପା ସିରିୟଲ ନମ୍ବର କେତେ? ସିରିୟଲ ନମ୍ବର 9 my lord. 9 my lord. ଚୈତନ୍ୟ କୁମାର ତା ବାପାଙ୍କ ନାଁ ଚୈତନ୍ୟ କୁମାର। ଆଉ ତାହେଲେ ଆପଣ କେମିତି ଆସୁଛନ୍ତି? ବାପା କୁଆଡେ ଗଲେ? ବାପା ମରିଗଲେଣି। କାହିଁ? ଡେଥ୍ ସାର୍ଟିଫିକେଟ୍ ଆଣିଛି my lord. I have pleaded also. So you first make a representation then. How you are coming for this? Did you represent?
Legal air certificate ଥିବ ଆଉ କିଏ ଥିବ କାଳେ claim?
Other legal air.
Yes. Did you represent? I am the son of the. That is true.
ପିଲାମାନେ କି ଆପଣ ଏକୁଟିଆ କଣ ସବୁ ନେଇ ପଳେଇବେ କି?
ସେଟା objection ପାଇଁ ରହିବ.
ପିଲାମାନେ ପୁଅ ମାନେ ଥିବେ କି କଣ claimants ଥିବେ ଆପଣ ବାପା କିଏ ମନା କରୁନାହାନ୍ତି ହେଇଥାଇ ପାରନ୍ତି ଆପଣ ବାପା ଆପଣ he the only child of that late Chaitanya Kumar Hari, the material before us.
My lord, there is 2 items, first item and last item. Their son are coming before this one court, and other 4 items are their name in the list, my lord.
other than 4 items, they are named in the list, my lord. 32 ର first ଆଉ last ହେଲା ଏଇ ୟାଙ୍କର ପୁଅ ଏଇ ସକାଶେ first ଆଉ last ଭାଗ୍ୟବନ୍ତ ପୁଅର ଏମିତି ସତ୍ୟନାରାୟଣ ତାଙ୍କର ପୁଅ ଆସିଛନ୍ତି।
Section 4 is a list prepared by the executive engineer.
Yes.
He is authorized
Yes.
to only calculate the structure.
Right.
But the
Other disputes he
Yes.
cannot. So let him make a representation.
it is the duty of the competent authority and land acquisition officer.
To make the representation, then
Yes.
that can be disposed of. Representation has to be made before the opposite party, Mr. Das. It is to be made
Land acquisition
before
officer and
land acquisition. Where is that?
Corina in general.
Land acquisition officer.
Land
ଚାରିଟା ହଉଛି ବୋଧେ ଇଏ।
ଚାରିଟା ତହସିଲଦାର
ତହସିଲଦାର
ନା।
ସେ ଇଏ land acquisition officer ହବ। ସେମାନେ NHI କୁ ବି ପାର୍ଟି କରିନାହାନ୍ତି।
NHI ଲେଖିଛନ୍ତି ସେ ଯୋଉ ନମ୍ବର ଦୁଇଟା ଲେଖିଛନ୍ତି ଜେନେରାଲ ମ୍ୟାନେଜର ଟେକ୍ନିକାଲ NHI।
Yes.
NHI should
ପରେ ଇଏ କରାହେଇଛି NHI ଲେଖା
ହଁ।
ହେଇଛି।
NHI should be represented.
So one representation has been filed, that is to collector annexure 1, but let them make fresh representation
Before the competent authority.
for the competent authority. I'm going to that is to be disposed of for them. Let them
Annexure
know.
1 ଟା 18 ଜଣ ଅଛନ୍ତି।
Hmm.
18 ଜଣ legal.
And we are so far as this case is concerned, like on the petitioner Bhagyavanta Kumar has filed this writ petition for a direction to the opposite party number 1 and 2 to pay compensation him towards legal cost over number so and so pertaining to Hasta number so and so of Mauja so and so in the district of Bargarh, which is stated to have been acquired for the purpose of four-laning of Sambalpur, Orissa oblique Chhattisgarh section of in the state of Orissa, and to quash the general eviction notice by Annexure 6. The Land Council for the petitioner drew the attention of this court to the report for the valuation report submitted by the executive engineer R&B division Bargarh relating in which details of 21 years have been mentioned along with the value of the structure, which is annexed to the writ petition as Annexure 4. The Land Council for the petitioner submitted that in serial number 9, the name of the father of the petitioner, namely Chaitanya Kumar, finds place, and the father of the petitioner is dead, and in support of such contention, he has annexed the death certificate by the Annexure 7. However, no legal certificate has been annexed to the writ petition. Let the petitioner submit a representation with a competent authority for compensation within a period of 2 weeks from today. And along with the copy of this order, on receipt of which, so also a copy of the writ petition, on receipt of which the authority shall take a decision within 3 months from the date of receipt of the representation. And if necessary, personal hearing is to be provided to the party, and order to be communicated within 15 days from the date of passing of the order. It is made clear that we have not accepted the opinions once or disposed of. Yes, similar order देखी हमने उड़ा कौन कौन
Your Lordship, other except the last matter, Your Lordship, the last matter is also the similar
First
matter.
and last is
first and last is same.
Yes, Your Lordship.
3076. It is like the same, है like the first one. हमने उड़ा कौन
The rest are covered by the order that I.
covered by the other case.
Yes, Your Lordship.
Mr. Amitabh Das that is appearing for the opposite party number 2 in NHI. How you are the 51. Opposite party number 1.
So let me indicate only one line if there is no other legal dispute.
Yes. If the parties concerned, like the party, if possible, so I give opportunity of the hearing to all the parties concerned. All right.
Your Lordship, until then, I may not, no direction, no steps may be taken to vacate my Lordship.
Get the compensation you are entitled to. Yes, next. Yes.
Obliged, Your Lordship. Item 40.
Item 40 is same. There is same.
That is annexure 9.
That is annexure also 9.
Annexure 9.
The number 3 is to be disposed of. No, only one prayer, my lord, is there. Till disposal only protected because if they will be evacuated of the entire.
Is to be disposed of within 3 months from the date of production of the certified copy of the order with the copy of the writ petition. And order to be communicated within 15 days of the taking of the decision.
One more prayer, my lord, similar matter also pending before this also.
Number
That is already admitted.
Copy number 1 and
Directed the state to take instruction.
अच्छा ओपी नंबर 1 ପାଇଁ ଆପଣ
1 and 4, Your Lordship.
1 and 4
Your Lordship.
1 and 4 ରେ ୟୁନିୟନ ଅଫ ପାଣି କନା ଆଉ मैडम को नाम सुलोचना पात्र लैंड सेंट्रल गवर्नमेंट काउंसिल है ना एगुड़ा को लिस्ट करे दियो
Only one matter, my lord, where the state has been directed to take instruction regarding the compensation and the acquisitions. Similar matter, same area, sanctuary area.
No, this should come. It are should list करे दो. Yes, next.
Item 41.
Annexure 4 is pending by recommendation.
Annexure 4 to be disposed of. Yes.
Item 42.
Annexure 4 man. Pending before opinion type RR benefits.
All right.
Item 43.
Yes, Mr. Das. What is the prayer in this? Consider the grievance on the representation 7-8 Asha. Annexure 2 is to be disposed of. All right. Yes, next.
Item 44.
We have disposed it of this previous item. Just the council could have I mean, presence record for just 44 years.
But page 91 is the impugned order. 91? 98, Page 98, the impugned order. Lots of members, when the RDC was not there, I filed this writ application. Your Lordship directed specific direction to take up the matter on the basis of the application I had filed for implementation of the status quo order. And Your Lordship specifically directed, I'll take Your Lordship to that. On the day when the matter was moved, if Your Lordship can the tenure of the order, which is
earlier order passed, have you
kindly have a look at page 84, my lord. Page 84.
84.
The operative portion is page 85, my lord. Accordingly, when the matter is taken up today, Mr. Katkia, additional government advocate appearing for the state, produced the later dated 21/8/24 issued by the Secretary Office of the Revenue Divisional Commissioner, Central Division, where it is stated that the matter will be placed in the court of the Revenue Divisional Commissioner soon after resigning. He has also produced the notification of the government of Orissa, J Department and Public Grievance Department. And it is mentioned that Sri P. Parmeshwaran, ISA Commission Consolidation, is appointed as the RDC, Central Cuttack. Since the appropriate authority has not yet started functioning to deal with the writ application, we expect that RDC Central Division shall take up the application filed by the petitioner under Annexure 13 soon after he joins and dispose of the same in accordance with law. However, order of status quo, dated 22/3/24, passed by the Revenue Divisional Commissioner Central Division, by Annexure 10 shall be implemented in letter and spirit till the matter is taken up by the Revenue Divisional Commissioner. Now, sir, kindly have a look at. I communicated the order to the Commissioner. Maybe he was very aggrieved that why I approached the High Court and direction is there. Normally it happens. Today the appellant filed. Kindly see that page 98. He says that your order has been quoted. Then today the appellant has filed an application stating that he has made to understand the construction has been carried out by the Department of Tourism, Government of Orissa, along with Orissa Tourism Development Corporation, praying and to add them as opposite party 4 and 5. Applications kept on record. He didn't pass any order on that. The petitioner contains that the impugned order of the collector, it is 16/9/23, is not a speaking order, and Section 3B of the OGLS Act is not applicable to the present instance. Peruse the original appeal petition filed on 16/10/23. Admittedly, land was allotted by lease case 13/12/2006 for construction of hotel for a period of 99 years. So-cause notice issued to the, by the Tahsildar for not constructing the hotel on 24/8/23. Clause 2, 6 and 4.2, the lease deed are explicit in nature. As per photo submitted of the petition, no construction except one pillar or two pillars were made on suit land for a period more than 12 years. For any status quo to continue, there has to be a prima facie case in favor of the petitioner. Hence, the order dated 22/3/24 maintaining status quo is withdrawn. All relevant records are available in case record. So no record was there, no para is covered, no nothing is there before the court. But he has dealt with the matter on merit.
No, that is not said. All the relevant records are available in the case record. As per the memo submitted today, construction is happening on the site. Hence, case is posted to 6/9. So what happened on 6/9? What happened?
So 6/9 adjourned, the matter is adjourned. So I am not done that manner. I am saying,
for what purpose?
sir, you received directed them to consider my application by Annexure 10. That application has not been dealt with. He has vacated the interim order. There was no application to vacate it. The commissioner had himself.
Which was kept on record is the addition of two parties. That is opposite party number 4 and 5.
Right.
That is kept on record.
Yes.
It's not that. But so far as the other things are concerned, he has just posted it to 6/9/24.
He has not dealt with the application that I filed. He has vacated the interim order. What is the question of implementation? If you also kindly see the earlier order of the court. Page 72.
No, we want to know that why it was adjourned. It may be at your instance it was adjourned.
Which one, Leonard?
On
6/9/24.
So I applied for because I have filed a late application.
Then you could have participated in the.
That is only for final.
Yes.
What I like to. So my short point here is.
Yes.
But I filed an interim application.
Yes.
Kindly, sir, look at page 72.
Yes.
(22 3/2024). The City Council appellant contend that interim application will be allowed. Necessary order as sought for in the IA may be passed for the interest of justice. However, on perusal of the case record, it is observed that view of the government opposite parties in the context has not received yet. In view of the above observation, IA filed with the appellant is hereby disposed of with a direction to both the parties to maintain status quo over the suit land till submission of placing of LCR parawise comment before this court. Order pronounced intimate all the concerned. But this order has been passed. Am I clear, Malad?
Yes.
During pendency of this order, somebody else started construction at the corporation, Malad. Construction corporation, the tourism development corporation. I immediately filed an application before the authority. It was not there, therefore could not be moved. Well, then I moved your lordship. Your lordship directed my application to be disposed of. My application for implementation of the status quo order. That has to be implemented in letter and spirit. That is your lordship's order dated 22/8/24. The interim order says the interim order is vacated. So no application is filed to vacate the interim order. Government has not filed counter. So Parawai's comment was there. No LCR was available. Now here in this instant case, 3B is not at all applicable.
That is to be decided on merit. Yes.
I have taken that ground also. And I have also said it cannot be retrospective, it must be prospective. There was also the virus office has
So unless you cooperate, how can that's a different matter that the status quo order is different, but you should also cooperate for the disposal of the appeal.
Sir, I am ready to cooperate, but the question is status. If you are also
tell us the when the
let the status quo continue.
Tell us the next date. What is the date?
30th.
30th. So 30th, all the parties have appeared. Who are the parties in that?
Sir, only government. And
now this notice has to go to this
two other parties.
Two other parties.
Right.
4 and 5.
4 and 5.
He has not passed any order whether he.
No order has been passed. In fact, sir, he has vacated without any application.
Added them as parties. He has just kept it on record.
No order has been passed. But with due respect.
No, in your interim application, did you make them parties?
Yes, sir. I filed an application to impute them as parties.
And after the order of status quo, the order was communicated. This construction has not come up after the order of status quo has been passed because it's a huge construction. It has been considered come for the establishment.
Construction
can't come. Your application was only month of March. It cannot be expected that such a huge construction will come.
With due respect, my lord, I couldn't have been standing before your lordship to make a submission on that. But they have constructed only after that. But now,
how can it be expected such a huge construction shown in the photograph if it is true?
So it has been done nowadays, day and night, they are going on with construction.
As for the photo submitted by so-and-so.
Sir, with due respect, it is done only after that. I could not have come. But if I approach the court.
For any status quo to continue. So, better you participate and that
main application be disposed of.
No, that interim order to continue, my lord. If you lordship kindly protect my till 30th, my lord, I'll participate. I'm ready to participate. And I know what the fate of the case also because of the view taken here. You peruse the appeal note and says that there is no prima facie case. See how the court has dealt with it.
Mr. Misra, you see, when an application was filed for addition of 4 and 5, so you should have either allowed it or disallowed it. If you keep it on record, how can you finally dispose it of?
Now, kindly call it tomorrow. Tomorrow I will come back with.
All right. Tomorrow. Because they are in the weekly.
The court has withdrawn the application.
I will come back with.
That order was there, and the order was very clear that after the LCR is received or Parawai's comment is received, that is to be considered till the whether it is to continue till the appeal is disposed of or not. Parawai's comment, as Mr. Misra pointed out, it is not received.
As on that day.
Then, as on that day. So records were not placed. So just vacate the order. What Mr. Misra merely because he approved this court, maybe that has.
That is the grievance, sir.
So,
sir, I appeal personally. The way he behaved, actually, I should not say.
So
he says that all right, you place everything, anything you want.
See, all right, you take up this number.
We'll take
it.
Valid. And 3B is not at all applicable. That I'll satisfy also if lordship wants.
Yes.
But my lord, as my lord senior is something, I will only add one thing. My lord, kindly look at the break. The petition was challenged virus.
Yes.
Petition was challenged virus of section 3B.
No, we are not only
we are not on
that, sir. That date is fixed to 38.
Yes.
It is to be disposed of, but before that, those parties should come on record. Because he has made an application it is to be in advance that order is to be passed so that notices can be served on those 4 and 5, intimating them that this matter will be taken up finally on 4 and 5. Whatever they want to do, any counter or anything, they can do it. But those orders should be there merely because that application is kept on record means they are not added as a party unless a specific order is passed that 4 and 5 are allowed to be added as party. They can have no right to say anything. So that application he has just kept pending, matter adjourned to for final hearing to another date, maybe at his instant. But the stay order was vacated. The status quo order was vacated.
Vacated without any application, without the record, on provisional of the appeal memo.
All right. Item number 40. Next item.
And that too, the previous commissioner, RTC, on provisional of the same has granted the interim order.
Yes, item number 45.
My regularization, prayer for regularization was rejected only on the ground of limitation. Out of 5 matters, 2 matters, your lordship already taken up these 2 matters. And today, my lord, item 45 and 47 listed today.
What orders have been passed?
Your lordship only directed they have to take instruction and this matter will come on 7/10.
Who is to appear for the
My lord and senior is appearing for 47,
47.
45, 47.
Dita agre
45, 47 দিতে দেন।
40 খালি এই প্রভু প্রসন্ন বেহান্ত আনারে এটা বাকি সব সেন্ড করে দেবো and this matter is to be placed with this matter 22365. It is posted to
7/10.
1720. বাকি সব
Extra copy.
extra copy. 45 or 47 dita na.
See.
Item 46.
46 made, please your lordship. My lord, I am on BC, my lord. My lord, this issue is regarding seniority of 46 and 48 are similar matters, my lord. The two
46 and 48.
8, my lord. 8.
Okay.
My lord, the 2 petitioners are junior clerk come cop-based under the Puri district judiciary, my lord. Puri district court. My lord, there was an advertisement in the year 2016 for 7 posts of junior clerk come cop-based, my lord. Ultimately, they appeared in these 2 petitioners appeared in the written examination as well as the viva, and out of the 7 posts, only 4 were given appointment, my lord. After that, the petitioners came before this honorable court. What I pray before your lordship, let those records of those 2 writ petitions be attached. That is WPC number 728 of 2018 and WPC number 242 of 2018. I will pass a slip, my lord. And what has happened now, my lord? Although they had secured rank 5 and 6 and 4 till 4 appointment was done, by virtue of the order of this honorable court, they were appointed to the posts which were kept vacant by this honorable court in those 2 writ petitions. Now the claim of these 2 petitioners are, since I had passed the written examination, eligibility criteria I had fulfilled, I was ranked at 5 and 6 and there were 7 posts and only 4 were appointed, for which I had come before this honorable court. Subsequently, in 2023, by virtue of the order of this honorable court, I was appointed. I am claiming my right of seniority from the year 2017 when the other 4 were appointed, my lord. What I pray before your lordship, my lord, your lordship may only allow me a time of 1 week so that
if you intend that your prayer should be like that, then the persons who are likely to be affected, they should be made opposite parties.
3-4 persons has to be at least.
You have not
have you come through the appeal committee?
No, my lord. That
then you have a provision for appeal, sir. You come through the appeal committee only. You can't entertain it.
My lord, I came across the appeal I haven't gone through the appeal provision, my lord.
No, yes. There is appeal provision. You have to.
Let it come next week, my lord. I'll file an additional
It has
affidavit
to come through appeal committee.
Okay.
and I will also make an amendment.
Learned counsel appearing for the petitioner submits that he has to examine whether the appeal committee of this court can entertain the prayer which has been made in this petition or not of this matter next week, along with this item number
48.
Item 49.
My lord, Annexus 6, page 42, my lords. This is a proceeding which has been drawn under Section 3, capital B of the OGLS Act. And my ground of challenge, my lord, I'm challenging the very initiation of the proceeding as it is without authority and without jurisdiction. My lord, since the lease was not granted under the OGLS rules 1983, which came into force with effect from 12th of March 1984. And in an earlier proceeding also, my lord, like Annexure 2, the revisional authority under the Act concerning the self-same land, my lords.
No, Annexure 6 you are challenging.
Annexure 6 is, I am challenging Annexure 6, page 42, as the same is without authority and without jurisdiction, my lord. Since the lease was not granted under the OGLS rules 1983, and the OGLS rules 1983 came into force with effect from 12th of March 1984, my lords. And the revisional authority, that is LDM, under the OGLS Act, he himself has already held concerning the case land. There was an earlier proceeding, my lord, under Section 7A of the OGLS Act, right, Annexure 2.
Have you given a copy to the council?
Okay.
So,
in that, my lord, I will take your lordships to page 29. It begins from page 27, Annexure 2, page 27, and relevant page is page 29. May I please, my lord?
Just a minute. This in the top it is mentioned,
my lords,
that WL case has been mentioned, and it is mentioned that under Section 3B of the OGLS Act.
1962.
1962.
My lords.
So this particular plot has been given.
My lords.
This is your plot.
Yes, my lords. I am a subsequent purchaser. I purchased 100 decimals of land.
Okay.
The lease was granted for an area of 500 decimals way back in the year 1974. And my main ground of challenge is, my lords.
Just let us.
My lords.
So why that proceeding was initiated?
My lord, that proceeding was initiated under Section 7, capital A of the OGLS Act.
And where is the document to that?
And annexed, Annexure 2, page 27. It begins from page 27, Annexure 2.
Yes.
I'll just place a little background to this before
you come to the operative
portion. My lord. Page 29. Last but one paragraph.
Page 29, yes.
Page 29, last but one paragraph. Last two sentences. Now it is required. Now it is required to be examined. It begins from that, sir.
Now coming to the legal aspect is one paragraph.
Same paragraph, last tinta sentence. Now it is required to be examined whether the lease sanctioned on 26/12/1974
is a lease under OGLS Act 1962 and the OGLS rules. It may be mentioned here that the OGLS Act 1962 came into force with effect from 26/11/1962. The rule is the operative part of the Act, whereas the same was not promulgated till 1984. Thus, on the date of sanction of the present lease, the only operative rule was the Lease Principle 1961, which came into operation with effect from 13/9/1961, and it was operative up to 1984 till it was repealed by a resolution of Revenue and Excise Department, letter number so and so, dated 11/10/1984. Full stop. The present lease is a clear case of sanction of lease under the provisions of Lease Principles 1961. And accordingly, my lords, they have that 7A proceeding was dropped, and the Tahsildar was directed to record the land in my name as per the registered sale deed. And this present petitioner was also a party to that proceeding. Now, my entire submission before the lordship would be that once there is a finding by the revisional authority under the Act, the additional Tahsildar could not have again initiated the proceeding under OGLS Act 1962 in the absence of any challenge. And I have also annexed the copy of the resolution, Annexure 7, page 43.
So, Mr. Ras, you can it will see that tomorrow it see this matter. And you will think that it will not is it will take of this matter tomorrow. Yes.
Item 50.
Okay. None is there. Next.
ये तो डिस्ट्रीजर्स हमारे इधर पर कैंसिल हुआ
ये इतना कम कर देता है, देखिए ये जो है पुल आउट कर देते हैं, ये कौन है सोचिए 1 month time he'll be getting many more time.
So will the council
Item 50, none is there.
चलो pass over to the next.
Item 51.
But I have filed this application challenging the order passed by the Chief Judicial Magistrate under Section 14 of the Securitization Act. But one of the basic reasons for which I have filed is, if you lordship kindly see your lordship judgment, where your lordship referring to the Supreme Court decision.
No, that is under 14.
Yes, my lord. 14. But projections to be taken, my lord. But your lordship in 2024 volume 6 SCC referring to the judgment has been delivered by your lordship, where your lordship said, if I come within the exception or special case under section 37 of the judgment, then the case can be entertained in a writ application. But I come within that category of exceptional cases, my lord.
No, this recently 5 judgments decision has been in that it should not be entertained at all if alternative forum is available. It was yesterday we and it was directed to be circulated to all the high courts. That was
yes, my lord.
Where is the decision?
No, that is,
That 5 years bench decision.
Not
Of
to
the
incident
Chief
rate of
Justice
period.
of India along with
and giving that one. But a number of judgments are there. Last,
recent,
yes,
recent, and that was asked to be circulated to the.
you're actually referring to Salib penalty.
No, that is in 23. This is 24. That is passed by Justice Pardiwala, which you are referring to.
Right.
No, that is not the one. It's a very recent one in 2024.
Just 1 second, brother. There is, I think, EHB improved is
The 5 years bench.
okay. There are copy है नहीं? नहीं?
No, 5 judgment. That has come only.
It does. I would say it.
Direction that we take to
It is Abdul Nadir.
Let us see. So this is the different parathesis referring to all judgments.
One more judgment has come, 5 judges bench. That is delivered by Chief Justice of India.
Okay, but
After this.
I missed it.
And that has just yesterday we come to know that about that.
I'll check up. I'm sorry. I should have been updated actually. I couldn't.
Very sorry. We'll take up tomorrow or next week.
Tomorrow. Next week, I'll sorry copy if you appear. If it's from the bank,
My name is there. Caveat is there. So he's entitled to get a copy.
I'll solve copies. I'll solve copies.
So they, land council appears for the caveat will get a copy of the writ petition, the served on small. So they put up this matter on 23rd actually. 23rd, 19th.
It's not indicated.
But I'm
In this recent one, that was that they were even going on issuing contempt. So please go through that.
I'm extremely sorry I couldn't see the judgment order. I'll check up on it. Because I got all those 2024 judgments.
Item 52.
May I please, Your Lordship? In this item, I have filed the writ application challenging the sale certificate. Already the auction process and the Securitization Act already has over. Therefore, this matter may kindly put up before the assigned bench, Your Lordship, single bench matter.
Sale certificate has been issued.
Yes, my lord.
So, who approved the alternative?
My lord, in this matter, e-auction dated 8/2/2020, 2018. Property has been already sold.
No, that
Sale certificate is already been issued.
It is already issued. That is annexed as Annexure 3. So
If
we are not in.
any grievances arises, my lord,
Please, if you want your name to be recorded, please fasten that your VNAMA or whatever you want. You are appearing for opposite party number 1 and 2.
I am for the bank.
That is what.
That is what I say
Yes.
that pass.
Like, this matter is come for the first time, my lord. We don't obtain the.
We are disposing of today.
Yes, my
If you want your name to be recorded, please pass on your name. We can record it. All right. Yes.
My lord, my sole prayer, Your Lordship, that liquidate the loan amount before the bank. Already I have filed the OTS application
Same
before the bank.
certificate has already been issued and you have got alternative remedy. We are not entertaining in view of the number of decisions, so disposed of it. Yes, next.
Next is disposal of representation under section.
Annexure 3 is pending with open number 2.
No, sorry. No, that is again entertaining that application.
Item 53.
Annexure 3 is pending with open number 2. My lord, present.
Yes.
Item 54.
The challenge here is to the order passed under Section 7A3 of the Odisha Government Land Settlement Act. This is unfortunately the third journey of the petitioner. The first, on 21st September 1987, without any notice, this revision was the order was passed cancelling the lease. That I assailed before this honorable court, and this honorable court interfered and directed it to give me a chance of hearing. Then they passed without considering my show cause, and that was again interfered by your lordship in the last order. Yes, that's 85-86 page. Personal kindly to 85 page. Page 85. Yes, madam. Annexure 11. 11, madam. That is order dated 1/2/23. That's correct, madam. All right. Please place that order. Let us see that. Learning counsel for the petitioner state that the petitioner's submissions were not taken into account by the ADM Bhubaneswar when he passed the impugned order. This is not disputed by the learned additional government advocate for the state opposite party. And accordingly, this matter was remanded back in view of the in that view of the matter, the said impugned order is accordingly set aside, and the said lease revision is remanded to the file of the ADM Bhubaneswar, where it will be listed for direction on 3rd of April 2023, and on that day, the petitioner will appear along with the downloaded copy of this order. The ADM is requested to proceed with the matter on merit, and after hearing the parties to pass the fresh order within the period of 4 months thereafter. Till such time, the interim order dated 19th February 2016 of this court will continue. Writ application is accordingly disposed of. The next annexure is annexure 12, page 87. No, what happened then? Then I appear on the date fixed. Then what happened? Or then the impugned order has been passed. Which is the impugned order? My lord, impugned order is at annexure 1, page 37. It begins with page 37. Yes. Yes. Page 37 it starts, and if a relevant portion, if your lordship find out, page 4040. Gone through the certified copy of the LCR from the Tahsildar. Has your lordship got 30? Page 4040. Relevant portion. 40. Yes. Gone through the certified copy of the LCR from the Tahsil, written submissions of the appellant and record available. It is observed that the lease was sanctioned on 21st 1 to 1974, and the order in suo motu revision case was passed on 21st 9 to 1987, which is within 14 years. The lessee sold the lease land in the year 1983, whereas there is an bar for selling of the land within 10 years of as per section 6A1 of the Wheeler Act. The lessee took the permissions under section 22 of the Act, but not under section 6A2 of the Wheeler Act. The lessee was also not belonging to the village where the land was leased out. The revisional court has initiated suo motu revision on the basis of the material irregularity, and the order passed dated 21st 9 1987 is within 14 years of the sanction of lease, though the appellant purchased the land subsequently and over possession of the same. The claim of the appellant over the land cannot be accepted, as the land was leasehold and the lease was granted to the lessee on mistake of fact and the procedural irregularity, which has been rightly cancelled by the revisional authority. Also, in many instances, the Honorable High Court has observed that a right in the law exists only when it has been lawfully origin and in an order at initial stage it's bad in law, and then all further proceeding consequent to be honest and have no necessary. So this is the my lord finding. Yes. Now my lord, I have disclosed each of the finding at paragraph at page 15 of my brief. Page 15 of my brief, I have given a tabular situation. On one side, I have given the grounds for my cancellation and the other side how it is demonstrated how it is wrong. Page 15 of the writ application. But in 1987 they have cancelled it saying that there is,
you have given here or
yes,
before the authority.
no, authority I have given everything. That has not been considered. This is the total finding. Not a single word has been whispered how dealing with my objection. Now, my lord, I'm coming back to this writ application. How do even these grounds are not tenable? Lordship, may kindly have the page 15. For the first ground in 1987 was just taken that there is a violation of requirement of Rule 3.3 of the OGLS Rule 1974 has not been followed. Now, this lease admittedly granted on 25th January 1974 and 1974 rule came into force on 11 December 1974. And I have annexed both 1963 rule was then prevalent and 63, he has not observed a single word with regard to violation of 63 rules. So at the time of grant, the rule which was there, it is satisfied. Now, my lord, comes to the second one. Proclamation inviting 3.5 of OGLS Act and Rule 1974 is placed. Again, my lord, 1970 this proclamation come, this rule applies is 1963.
Yes. Yes.
Third, my lord, section 3.2 of the Act wherein it is provided that 70% of the government land should be settled in favor of ST and SC. I am an SC. The initial lessee was an SC. So there is no material to produce that this has been violated. Besides the fact that this is, so all these I have demonstrated. Then again, for section 3.3 violations, how it's 62 Act, 60.
The writ petition has been filed by the petitioners for passing the order dated 13/10/2023 passed by the opposite party number 4, the additional district magistrate Bhubaneswar, in lease revision case number 740 of 1987, as well as the orders passed by the opposite party number 3, the assistant settlement officer Bhubaneswar, in the rent objection case under Anisha 10 series, with a further direction to direct the opposite parties to issue record of right in the name of the petitioner in respect of the land purchased by the petitioners. The land counsel for the petitioner drew the attention of this court to the order passed by this court dated 1/2/2023, passed in WPC number 23303 of 2015, wherein this court, while setting aside the order of the additional district magistrate dated 8th November 2006, remanded the lease revision case to the file of the ADM Bhubaneswar, and the ADM was asked to decide the matter on merit. The land counsel for the petitioner submitted that in pursuance of such order, the impugned order was passed, and the grounds on which the impugned order was passed and it was
hold that the revisional authority was right while passing the orders dated 21/9/1987 and 8/1/2006 in revision case number 740 of 1987 are correct, not sustainable in the eye of law. He has referred to the grounds for cancellation of the lease by the revisional authority and the reply to such grounds as mentioned in paragraph 11 of the writ petition. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. The Land Council for the state accepts notice on behalf of all the opposite parties. Extra copy of the writ petition be served on the Land Council for the state during course of this week. Matter be listed up to 4 weeks, counter if any, be filed in the meantime. IN numbers so and so till next step the status quo over plot numbers so and so shall be maintained. Yes.
Please.
Item 55.
May
Petitioner's first occurred one after the government in 73. The 50.5 lakhs only compensation, waste compensation is pending before the land acquisition. The representation is annexed 4 million pending before land acquisition CORAM Act.
Annexure 4 is to be disposed of. Next.
Item 56.
Well, the petitioner's residential house is acquired by the Ministry of Transport and Highway, and compensation is calculated to some extent, but clarification is sought for from the Chief Temple Administration by the competent authority. Annexure 3, page 17. National Highway Authority, Mr. Das used to appear. Have you served a copy? Indeed. They don't, it will be taken up next week. You give a copy. Mr. Amitav Das, who used to appear for the opposite party number 4. Let a copy of the writ petition be served on Mr. Amitav Das, who used to appear for the opposite party number 4. During course of this week, matter ministered next week, indicating the name of Mr. Das in the positive. Yes.
Item 57.
Made challenging the auction notice in the annexure 4 million. Legal one notice is Let's kindly turn to annexure 3. After declaration of entry and possession notice in public miller, he has already deposited some amount about 9 lakhs. You are for the?
I am for the opposite party bank. I have entered a caveat. So, upload the appropriate form. Disposed of. Give your name, Land and Council, so that your name can be mentioned.
Date of auction is 20th. May I pray?
File after. Yes, next. So, Passover, how much? 30.
Passover item number 4.
Mr. Soruna Naik. Next.
Item 9.
Your Lordships will see Lordships order number 1 minute. Let's here the land is not under notification.
Yes, just a minute.
And-
Order number one.
Order number 1 of your lordships,
Petition was on
21/8/20.
main contention that has been raised by one counsel. Concerning the notice dated so on the initial file were not there in the notification letter.
But in any case, you have purchased it only after the notification.
That
You have no locus standi to challenge this.
this land is not under notification and they are trying to acquire. That is my case.
Mhm. That is not your case.
The
And perhaps my learned friend will also agree that
exactly
No, no.
order number one.
there is
Order number one, let's say that was his contention. That the two plots which have been mentioned in the notice dated 15/7/2024 under Annex 5 were not there in the notification under Annex Section 11 of this one, 2013 Act by the Annex 6 dated one. So there is a time gap of more than 4 years between the notice dated so on. And counsel for the state seeks some time to obtain instruction as to how the two plots which were not there in the notice dated so came to be included. So that was the intention.
Well, in this case, the present petitioner purchased two plots, Your Lordship.
Hmm.
One is 419, Khata number 31, and another is plot number 413, Khata number 108. First time coming to 419, Your Lordship. That plot he was purchased from one Govinda Bhukta, and that plot was acquired, my lord. That was acquired on 2/8/2018 by 11/1 notification, Your Lordship. And after the residuary plot, so 8 decimal was acquired, and rest property he has obtained an of permission and sold it to the present petitioner. Then, so far the second plot is concerned, my lord, that was not acquired, and he purchased the plot. But in the meantime, Your Lordship, kindly have a glance to page 32, Your Lordship, of the instruction. Yes, yes, my lord. I have given it. Aye.
You want it next week?
no, tomorrow. You know.
Tomorrow. All right.
Published.
Yes.
Item 13. Yeah, please, my lords. My lords had asked me to take instructions whether there is any stay operating against. My lords, I've got instruction. There was no stay. The stay which was granted was conditional that they have to pay within 1 week, and the payment was never made
Just
within 1 week.
within course of it is pointed out that there was a stay of passed by, which is confirmed by Supreme Court.
May I submit my I am appearing for the borrower. The copy of the writ petition may be served. I will explain. The deposit amount of rupees 8 lakhs had been made before the DRT Cuttack. That has been as per director of the and received the money. Entire 38 lakhs out of 46 demand has been received by the bank, and as a condition.
No. Now what is the prayer in this? We are not entertaining this day. What is the prayer in this petition?
My lords, the writ petition.
Yes. What is your prayer?
My lords, just since my lords had raised a question of limitation. My lords, the police.
What you are challenging here,
My
madam?
lords, we are challenging that despite the collector passing an order under Section 14, the police is not cooperating and taking possession of the property which they are obliged to in under law under Section 14 of the Supplementary Act. We,
Which
as
order was passed, which is not being administered?
18, my lords, it's at the list of. My lords, because of the intervention of COVID period, nothing happened, but we have been trying since 22. 3 dates, the police have gone to the site and not taken possession, saying law and order situation will be created. My lords, that's the entire reason why Section 14 has been incorporated, because we know when the government bank takes or any bank will
to the securitization, there will be opposition from the borrower who would like to squat on the property, my lords. And my lords, with 13(8) amendment, that he loses the right to redemption once the auction notice is given. And in this case, my lords, auction has been carried out, sale certificate has been
No, it's
issued.
all right. This 14 proceeding, what happened? The order was passed.
Yes, my lords, the order was passed as early as, my lords, just a minute. My lords, the list of date and events. Yes, my lords, on 22/5/2019. Section 14 of the Surface Act, which is...
No, is there any latest order?
My lords, it's...
My lord, letter is only to be implemented.
My
lords.
My lord, recall on that last occasion, my lord, I was placed the annexure
Yes.
for my lord.
My lords, annexure 4, we have...
And accordingly, my lord directed to take instruction whether there is a stay order of the DRT or not. That is the question that to answer, my lord. My lord, may kindly come to page 25.
My lords, I'm ready to
Yes, just a
answer.
minute. 25.
My lord.
Yes. Madam, did you file affidavit that the stay order is not in force? Then?
I prepared a small written note of submission.
No.
Pass it on.
Very for us was that a stay order of the appellate court is still in force.
Yes, my
You
lord.
file an affidavit.
My lords, I'll file an affidavit.
That's all.
That's all.
Written notes, I'll make it in the form of an affidavit.
You file affidavit, then we'll send.
No problem, my lords. We'll file it. We'll file it by Monday.
Essay is pending and essay is already party had in part and posted for final hearing on 26th September of.
Yes.
My lord, there are 3 Supreme Court
Counsel
judgments
for
totally in my favor.
Petitioner wants to file an affidavit
My lords, by Monday, we'll file it by Monday.
by Monday. Put up this matter, giving copy to the, you are appearing for whom?
I am for
auction.
For my opposite person.
Auction purchaser.
I am for the borrower.
To the other parties, including the state, matter to be listed in the commencing from 30th of September 2024. Yes.
All the amounts transferred as per the appellate tribunal 30th.
Yes.
Okay.
Next.
Item 4 right paso.
Quota. Yes, Mr. Nair. And who is appearing for the Union of India? The party is there. Anybody CGC? No one is there. What is your fare in this? Oh, you are there. Oh.
Yesterday, my lord submitted the report, my lord, the land acquisition officer. My lord is for the what is the recovery procedure of the commission amount if it is paid to any other wrong
Yes,
person.
other than the
Other than
awardee.
that is the my lord.
Report, the award has been given to a wrong person.
That's
Not attractive.
yes.
So,
And section 84, your lordship kindly have a glance.
which act?
My lord, right to fair compensation and transparency in land acquisition.
2013 Article of
2013.
section. Which section you want to?
84, my lord.
84.
My lord. It can proceed against that person.
Just a minute.
If a person in connection with a requirement of direction under this act provides any information that is false or misleading or produces any false document, he shall be liable to be punished with imprisonment either
again 64.
prescription
For everything it
which
is
may
64.
extend to 6 months or with fine which may extend to 1 lakh rupee or with both. And my lord,
Here question that it has to be recovered fast.
my lord,
Recovered, that is under 64, there is no dispute about that.
yes,
The person to whom it is payable.
my lord,
So suppose somebody has been paid wrongly, he was not entitled to because he has already sold the property to you according to you. So the wrong person has received the compensation, right? So now the way out is 64,
yes,
and he has also directed the concerned person to appear
yes,
and refund the amount.
yes,
That is not
refunding.
So in that case, what is the way out? We put the
My lord,
question.
there is a provision also, section 33, that empowers the collector to correct its order, my lord.
No, that is the
No, let us kindly come to the
correction to award.
rule, rule 14, madam.
1-4.
1-4, madam.
Rule,
madam. The right to fair compensation. Yeah.
Mm. 2014 rules.
2015, madam. 2015.
Just a minute. 2015 ର ଗୋଟେ rule ଅଛି ଯୋଉଟା ହଉଛି right to fair compensation and transparency in land acquisition so and so. Rules 2015. अच्छा.
Compensation, realization and resettlement development plan. Rules 15, madam. Rule 14, madam.
Section 14. अच्छा.
214. Inquiry of rehabilitation and resettlement benefit. Any rehabilitation and resettlement benefit availed by making a false claim or through fraudulent means shall be recovered as arrear of land revenue under the provision of Revenue Recovery Act.
OPDR Act is there. That yesterday we have been discussing.
Madam.
That's it. That will be taken as a area of land evidence and OPDR Act will come into play. Besides the fact that the FIR can also be filed.
No, that is under section 84, madam. Penal section is there.
At whose instance it is to be?
That
If
authority.
you are CEO, then the authority has to.
Yes. Yes. Authority. Yes.
So why he has not initiated? Yes, that is the question here.
He called him for personal appearance. He did not. So he can initiate with that.
Have to take, madam.
And in 64, and the correction can be made in other provision in 33.
And 85 is the penalty, and
that's a different.
That's a different.
My lord, what instruction has been given, a undertaking has been given by that person that I will refund that money.
Oh, that is there. So what?
Undertaking ଦେଇକିନି ବି ଫେରଉନି
yes,
ତାହେଲେ
yes.
ପୁଣି ପଇସାଟା ତ ଆପଣଙ୍କର ଆଦାୟ ହେଇ ଆପଣଙ୍କୁ ଦିଆଯିବ ନା ନାହିଁ ସେଇ ପ୍ରୋଭିଜନଟା ସେ ଦେଖୁଛନ୍ତି ସେ ଇନିସିଏଟ କରିବେ ଆଉ କଣ.
Look, this writ petition has been filed by petitioner Hemanta Kumar Mohanto. For a direction to the opposite parties number 1 to 4 to pay the awarded compensation to the petitioner for acquisition of his land pertaining to khata number so and so, plot number so and so, prayer portion, the area so and so, है ना? The further direction to the opposite parties not to occupy the rest portion of the plot number so and so except area person. The Land and Council for the petitioner to the attention of this court. Order to place court with the direction the
My lord, that instruction has been submitted by my lord and state council.
अच्छा सेटा काली जोड़ा ଦେଇଥିଲେ.
My
yes. It is the contention of the Land Council for the petitioner that upon court election को paragraph रे जो wrong person को दिया लावली.
My lord.
Paragraph number.
Paragraph number, my lord. Paragraph number 7, my lord.
7. Court election. जोड़ा इतने पैराग्राफ लिखछे असल जिनसडा लिखिना दिना कोन.
My lord, paragraph 80 has been stated, my lord, petitioner is the owner.
So, the news is that it has been paid to a wrong person. Where is that averment? We are asking you that show us that. He is no way entitled to get that money, but he has taken it And that is why you have filed this writ petition. What is that government? And who is that person?
Person is OP number 5 my lord.
अरे बाबू government कहीं food पहुंचना दिया वो.
You have straight jumped to that part in para 11. When the matter stood thus, the petitioner as well as opposite partner 5 were issued with notice.
Paragraph 10.
Paragraph 10. अच्छा.
My lord.
कौन तो copy?
My lord, that pursuant to the application under RTI Act, collector dated magistrate, it has been intimated by the office of the deputy collector IPO that he was stating there is that application has been transferred to authority to provide information.
No, that is not. That is different. You come to the paragraph number 12. Let us see. Read it off.
Yes. That in obedience to the said notice, both the petitioner as well as the opposite party number 5 on 15/4/2024 appeared before the opposite party number 3. The opposite party number 3 in LA case number 11/2018 made an inquiry from opposite party number 5 regarding the acceptance of the compensation amount for acquisition of the plot number so and so, correspond to khata number so and so, measuring an area so and so, my lord, is acquired Mauja, Pavitra Tahsil, Sadar, and petitioner was also present in that inquiry and stated before the opposite party number 3 that he, being the true owner of the aforesaid property, was supposed to be awarded with the compensation for land acquisition, and instead of awarding the compensation in favor of the petitioner, whose ownership of the property have been confirmed to the mutation RR dated of opposite parties, have wrongly awarded compensation in favor of the opposite party number 5.
Right. The land counsel for the petitioner drew the attention of the court to paragraph number 12 of the writ petition, which indicates that the compensation amount has been wrongly that is
13th or more clear, man. 13th or more clearly actually
awarded so and so in favor of the opposite party number 5, and the opposite party number 3 so and so instructed the opposite party number 5 to refund the awarded amount on the ground that it has been wrongly paid to him instead of the petitioner. And he also drew the attention of this court to paragraph number 13, wherein it is mentioned that's one. So it is the land counsel for the state yesterday filed the report, the later dated so and so of the special land acquisition officer so and so rail link here, wherein it is mentioned as follows: for this
that's out of the
telephone is on the people of the state that he has paid the amount in medical care. He was with the order of the in the meantime, this was
this order has come on 12/9 only. So we have to wait for that. It's a 12/9 day order capacity, directing him to within 3 days. As some medical case had been taken place in his family. In the meantime, this office again directed sir regarding action.
He said that he had paid the amount. He will pay. Within 3 months, I have some
but he had not submitted any statement in this matter till date. Then he will take action.
Section 14, Rule 14 of the right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement, bracketed compensation, rehabilitation, and resettlement and development plan, bracket ends, Rules 2015. States as follows: quote, Rule 14 in entirety. The Land Council for the state submits that since admittedly this opposite party number 5 has received the compensation amount is not entitled to, and in spite of repeated communication by the special land acquisition officer to refund the same so that it can be given to the petitioner, he is not complying the order and taking one plea the other. The recovery proceeding has to be initiated in terms of 2015 rules. Let the appropriate steps in consonance with Rule 14 be taken up. Within a month, you initiate that proceeding.
60 lakhs 600. 63 lakhs.
63 lakhs.
63 lakhs 600.
That amount 63 lakhs, no more 63
Sorry, 63,000.
amount
600.
Yeah, amount is I mean, entire se paragraph to quote for so you take step within a month, okay, and hand over the amount should be handed over after recovery to the petitioner. Copy of the order is sponsored. Petition is disposed of.
Lordship under 1 month. Lordship allowed 1 month.
1 month to institute that proceeding, recovery proceeding, that is to be disposed of in accordance with law, and after its recovery, it is to be handed over to you.
Lordship also a time limit.
Yes. But that requires service of notice. If we fix the time limit, if he avoids the notice, it cannot be disposed of.
Like 2 months.
So, 2 months for institution of that, or 2 months.
Our appearance is noted, my lord. DSI along BK Party.
BK Party in Central Government Council. Yes.
Supplementary list. Item number 50. Lordship, kindly allow extension of proper discharge requirement. Kindly allow extension of proper discharge requirement. Extension.
Decision recruitment. That is to be extended.
Yes.
For 1 month.
Yes.
You're getting more time now.
Lordship,
I don't think that advertisement is still there, or it has been pulled up.
But
Kindly verify.
Verify.
Lordship, very short time.
Kindly verify whether the advertisement is there or further advertisement will be there. Withdraw section देखो.
ସେଟା ଗଲାଣି ସେ ନୋଟିଫିକେସନ ଟା ମୁଁ ଏଇଟା ୱିଡ୍ର କରିନିଅନ୍ତୁ ହେଲା ସେଟା ଆଉ ଥରେ ନୋଟିସ ହବ ହେଲା Grant counsel for the petitioner seeks permission to withdraw the application or dispose of it.
Supplementary list. Item number 1.
Yes, Mr. Dawes.
Lordship, in fact, last occasion, I had given a dead chat. Will Lordship permit, then I can place the dead chat so that the sequence of events can be Lordship brought before Lordship. But the time, Lordship, kindly see it is around 1 o'clock. Time, Lordship, is around 1 o'clock. At least it will
take more time. So we can take up
Lordship fast case because of today or tomorrow fast case, Lordship, so that in supplementary list it is there, Lordship.
No, now the this is finished. This
weekly finished, Lordship. So automatically it will, Lordship.
All right, to खाली रखते थे. Yes.
Imprimatur control, Lordship.
Yes.
Lordship.
Item number 2.
Right. Yes. Your Lordship has already heard the government. Your Lordship may first take Annexure 3 at page 23. This is the judgment of which was delivered by this Honorable Court. Paragraph 4, Your Lordship may see it by page 22. We allow this appeal and set aside the order dated so-and-so of the learned single judge and direct the authorities to record the suit plot comprised in plot number so-and-so having an area of so-and-so. In the name of the appellant, we make it abundantly clear settlement authorities may proceed under Section 3B of the OGLS Act if they are so satisfied that there is such requirement. This was the order of this Honorable Court. Thereafter, my lords, Annexure 4 at page 24. This is the application which I made pursuant to the Honorable Court's order for recording my name. Now, next, Your Lordship may see Annexure 10 of the which is attached to the rejoinder at page 8. This is very important. Your Lordship may kindly see this relates to mutation case number 31446 of 2023. Now, Your Lordship sees there are 4 orders on that page. 3 orders are of 12-10-23. And the 4th order, Your Lordship may see, this case is taken up today. Peruse the case record from which it is revealed that the suit land is already mutated in favor of the applicant, while mutation case number 5899 of Moja so-and-so. Hence, the case is rejected. Close the case and consign it to record rooms. So 31446 of 23 was closed because for the self-same land, for reasons best known to the Tehsildar, he registered another case, which Your Lordship will get at page 32 of the writ petition, Annexure 7.
That is also in your name.
Same plot.
No, same plot, and it has been recorded in. It is mentioned.
Yes, it has been recorded in my name. My name.
Yes.
Now, in both the cases, if Your Lordship sees the order sheet, they are identical to each other. The orders are identical to each other. It's almost copy-paste of each other.
Which one? Annexure
7 at page 32 of the writ petition and Annexure 10 at page 8 of the rejoinder. The first 3 orders are copy-paste of each other.
Okay, then
next, Your Lordship may see Annexure 11, rejoinder page 11. Yes. Let it 10 more now. Okay. This was information was obtained by me at page 9. Your Lordship will find it was obtained by me under RTI. No, this is not an RTI. Your Lordship sees this is the report, Tehsildar's report, and page 11 is the report, inquiry report. Now, at page 12, column number 5. Last 2 lines, hence the transfer was effected after the due lock period. Now the land in question is being used for agriculture purpose. This is the Revenue Inspector's report on 16/10/23. The signature of the Revenue Inspector is important.
This is in page number 12.
Page number 12. That signature, your lordship may just keep it aside. Now, your lordship may compare that with annexure L by 5, which the state government relies upon to say that the land is not agricultural. L by 5 at page 45 of the counter. Kindly compare the signatures of the two officers. It's the same person. And here he says, on 16th of October 23, he said it is being used for agricultural purpose. Now the same officer says that the land is lying fallow with recently planted saplings of papaya tree, and it is land bounded by compound wall. Also, it is not used for agriculture purpose.
But we pointed out that the WL case numbers which have been mentioned, they are something different. We said to you this annex.
Same land. I've shown to your lordship the order sheet.
Might be same.
Order sheet in both the cases.
No, just please come to page number 11.
Page number 11 of the writ petition.
No. Is that rejoinder affidavit?
Rejoinder.
Just
Yes.
And because 12, column number 5, you are placing that.
Yes.
So page number 11 in the top portion, it is mentioned that what is the WL case number.
Yes.
And the WL case number, in fact, is 1278 of 2020.
Yes.
Now you come to that, the counter affidavit, that report.
1278 of 74, same case.
Just a minute. The in connection with the WPC, mutation case.
Mutation
case is
899.
Mutation case is different.
And the writ petition number is wrongly mentioned in one of them. Writ petition taku writ appeal taku writ petition record gochati. First 23 record.
So, Mr. Mishra, have you tried to explain this thing in that I showed
the malafide. They say the other day my learned friend made a statement that a proceeding has been initiated against a person who has given a report that it's agricultural. Now, kindly see the officer who is given the so-called correct report has signed two reports. One is at page 12. At page 12 of the rejoinder.
Is the same person.
Same person. Kindly see the signature. Signature at page 11.
That means admittedly there is a manipulation.
Yes.
So that report cannot be believed. Either of these.
I saw both report cannot be
believed. Yes. In that case, the report that is to be accepted is what has been obtained here, and I have annexed to the writ petition, which says it's agricultural land. I'm using it for agricultural purpose.
So the person who could give subsequent report on the self-same land,
contrary to the first report,
how can the first report be said to be a proper one?
Now kindly come to page 2028, annexure 5 of the writ petition. This is another inquiry report which is dated the 30th of March, the latest one.
No, this is the same number.
No, it is
33. Here, has he said this?
Kindly come to page 29. What he has said, this is a different revenue inspector.
And that is what?
Kindly take column 5. Last 4 lines. Hence, the transfer was effected after the due lock-in period. On field verification, we found that there are 50 number of papaya trees, 30 number of teak trees, which are under beneficiary scheme, 1 permanent water tank reservoir, and about 1 truckload of cow dung stack with well plowing for cultivation. The land in question is being used for agricultural purposes.
No. In which mutation case this is referred? Mutation case number 31446.
446.
And the other one is different.
5 double, both relate to the same land.
But how there could be two?
That is something that they need to answer.
Cannot be two.
They need to answer that.
Rejoinder copy is my material.
I'm told that it was served yesterday, but I've not got it. I got it.
So the petitioner has, it's a suo motu or on the application of the petitioner for mutation.
My application for mutation pursuant to your lordship's order in the writ appeal.
Only one.
Yes.
No other
No application, other application.
I'm explaining my notes. These two mutation case numbers. So,
Because this annexure 5, just look at that number. Mutation case.
31446 of 23. Another is 5899.
And another thing, Mr. Mukherjee is submitting that this report is the latest one.
This 33.
The other two, let us leave those. You have initiated a proceeding against that man. No, yes, they say I have proceeded against this man. This man. That is what my learned friend said.
What was my submission to be found of court? Is this?
They should have proceeded against that other person who gives two contradictory reports.
This report dated 33/24 and annexure 5 is not to be believed because this relates to a mutation case number 31446, which is not the mutation case, madam. I have shown madam that in page 42 of the read. Madam, can you turn to page 42, the appeal order?
I kindly see the line schedule in both the mutation cases.
42, madam.
Page 33, what line schedule is
42.
Page 33 of the writ petition.
Land যদি ସମାନ ହେଇଥିବ ଗୋଟେ particular land ଟା ପାଇଁ କେତେ ଥର mutation case initiate ହବ ଗୋଟେ land particular ଇଏ ପାଇଁ mutate କରିବା ପାଇଁ ଗୋଟେ ହବ ନା ତିନି ଚାରିଟା ନମ୍ବର ତେଣୁ ଏଇ ଯୋଉ ନମ୍ବର ଗୁଡାକ ଡିଫର କରୁଛି ପ୍ରତ୍ୟେକଟା ରିପୋର୍ଟରେ ତା WL କେସ୍ ନମ୍ବରଟା ଠିକ ରହୁଛି କିନ୍ତୁ ମ୍ୟୁଟେସନ କେସ୍ ଗୁଡାକ ଅଲଗା ଅଲଗା ଯୋଉ ଦେଖୁ ସେଇଥିପାଇଁ ଆମେ କ୍ଲାରିଫିକେସନ ମାଗୁଛୁ accordingly ଆପଣଙ୍କ ରିପୋର୍ଟ ବି ଅଲଗା ହେଇଯାଉଛି ତେଣୁ mutation case number is different, report is also different. In one report it is stated that it is being used for agricultural purpose, in another report it is just contrary. He is annexing one report, it is mentioned
in one mutation case. You are showing in another mutation case.
Land schedule. Kindly compare the land schedule in the two mutations.
Most important. If land schedule ta jodi saman thibo dita jo tinita jago report apno verify korbe tinita jago iye re jodi land schedule saman thibo tale kemiti tinita mutation case initiate hela gote particular land pai tinta mutation case kemti initiate hela tini prakar report kemti asuchi
50 papaya tree jagare 45 hi pare.
No.
But how could it be that there is no papaya tree altogether within a span of 3 months?
As reflected in the new law.
And why 5899 of 2024 has been initiated if earlier mutation was there?
Yes. So that
this is a mutation case number 5899 in 2024.
ଆପଣ ପାଖରେ ବର୍ତ୍ତମାନ ତିନିଟା ମ୍ୟୁଟେସନ କେସ୍ ନମ୍ବର ପାଉଛନ୍ତି ଦିଟା
5899
ଦିଟା କେସ୍ ମିଷ୍ଟର ମୁଖାର୍ଜୀ କହୁଛନ୍ତି that relates to the self same ତ ଏଇଟା କେମିତି ଇନିସିଏଟ ହେଲା ଦିଟା କାହା ଇନଷ୍ଟାନ୍ସ ରେ ଇନିସିଏଟ ହେଇଛି ଆଉ ରିପୋର୍ଟ ଗୁଡା ମଧ୍ୟ ଅଲଗା ଅଲଗା ଆସୁଛି
and other one was 31446 of 23.
That is the
earlier one.
That was dropped because
in this earlier one. The report has come in 31446 of 23 of dated 30th March 2024 by a different RI.
This as per my instruction was wrongly.
Anyway, whatever.
କାରଣ ଲିଷ୍ଟ ସେ ନେଇଥିଲା ଏଗ୍ରିକଲଚର ପର୍ପସ ପାଇଁ obviously ସେ ଯଦି ୟୁଜ ନ କରୁଥିବ you are entitled to for that resumption case. But if in view of this reports, if he is using it for the agriculture purpose, so a papaya tree achi, amko achi, cow dung achi, jahan se reservoir achi, tenu kemti taku that initiation.
And may I also state before your lordship, this land is in Andharua Mauja. This is perhaps the only land which is being used for agricultural purposes. All other lands have been converted to homestead. Institute of Mathematics is there. So this story of this being a jungle land is something like saying what they had argued at that NALCO matter, that NALCO is the jungle land. NALCO office is in jungle land.
So we'll take off, or you want to obtain, we can take up this matter next week. That would be better because get clarity.
you call those officers that how this, and call that I think better you call those mutation case records. Okay.
No, I've given the entire certified copy.
Huh.
The entire certified copy is there.
So
Can't be
there
anything
you can
different.
get the clear picture, have a discussion that what is the correct state of affairs. So we can take up on Tuesday or Wednesday next week. Uh, 25th. All right. 25th.
No, not on 25th. 25th, there is already a matter fixed. Your Lordship may either take it up on 24th or 26th.
During course of argument by Mr. Gautam Mukherjee and senior advocate, Mr. Misra submitted that he wants to obtain certain instruction and the matter will be taken up next week on consensus of both the parties. Place this matter on 26th September 2024. All right.
Weekly list, Passover item number 19. May I please, Your Lordship? My lord, hearing this case, the appellant is convicted for the offense 304 for life and for 10 years for the offense 307 and for 452, my lord, for 5 years. And my lord, the appellant is inside custody since 31/10/2015.
Have you got that custody certificate?
Most order pass before your honor, my lord.
And he was granted interim bail for a period of
2 weeks.
2 weeks. As per order dated 5/1/2023. Perhaps it is wrongly typed as 2003. And there was a direction that he shall not indulge himself in any criminal activities. So you get the custody certificate and also the instruction regarding his conduct during the period of interim bail. Sir. IA number so and so, this is an application for bail. Learning counsel for the appellant submits that the appellant was taken into judicial custody in the year 2015.
Right.
And he was granted interim bail. He was not on bail during trial.
No, madam.
He was not on bail during trial. And during the pendency of the appeal, he was granted interim bail for a period of 2 weeks as per order dated 5/1/2023.
Right.
And after availing the same, he surrendered at right time. Let the land counsel for the state obtain the custody certificate of the petitioner through the concerned jail superintendent, and also instruction regarding the conduct of the petitioner while on interim bail put of this matter midweek commencing from 30th of September 2024.
Much obliged. Item number 24.
Next.
Item number 28.
May I please, Your Honor? I'm in the CRA number 384/2024. Appellants are women and they were on bail while under trial. And one of them is 70 years old and another one is 100% blind in the eyes. And as per the...
Just a minute.
My lord, as per the witness number 7, who is the actually witness, he was telling that she has
This is
reposed.
where 5 murders.
Yes,
were-
yes.
So, what is that ground you have taken? So somebody is blind.
One is blind.
Let us see
Who is
that, where is that ground taken? Nothing.
My lord, the appellant number 4.
Mr.
That-
Counsel, we have stated that where have you taken that somebody is aged about this, somebody is blind, where have the grounds have been taken? He has to verify, na? अभी आप मुहेरे कह दिला मैं अपन को
Page 11, my lord, blind certificate. Page 11.
Page. This is item number, criminal appeal number.
384 of 2004.
384. 84 of 2050. No, that is stay appeal.
I've taken the appellant number.
Just a minute. तो 9 है भाई এটা হচ্ছে 3
and next 4 করে দিয়েছি।
I am number 1 এটা ওটা main I remember that is which apparent there are in this case as we find there are 5 apparents and you have applied the bail for all the 5. All the 5.
Indu Maji. ये तो no.
Indu Maji is apparent number 4.
My lord. Indu Maji. कौन सा रहेगी? Disability in relation to her both. Appellant number 1 is 69 years old. Appellant number 1 is 69 years old, lady.
Oh.
Now she has been shown as blind for the first time here, or earlier also such a step has taken. At any point of time, this plea has come, or for the first time. In this PL application I have given, I think they have given the medical certificate of that is all right, but his disability certificate was produced earlier because she was on bail during trial, as you said. Was it a ground there? No, I don't think so. All the 5 were given bail, all the ladies. And another thing I'd like to press, the PW number 7 in the page 1 and 8 of my petition, first line. She has told that all the women culprits are holding lathi. She is telling that all the women are holding lathi. And whereas the doctor Vishwajit Joshi, PW 11, in the page number 135, he has specifically said, except the ladies,
wooden sticks, all other weapons are sufficient to cause death in the normal cases. So I want to say when we are holding the conduct, then we are not responsible for the death.
5 persons were
all ladies
assaulted.
Well,
So,
no, 19 people have asserted. 19 people have been convicted in this case.
No, it's all right. They have been sentenced to life imprisonment, and you were everybody has stated you also, these ladies also participated in the assault, and they were holding lathi.
That is actually disputed fact, because the witness who was there, she was telling that I was hiding and I am not coming to that.
No, we are not. At this stage, we are not going to appreciate the evidence.
I wanted to say, because we are holding the lathis, we are not responsible for the death.
No, if lathi blows are there on the deceased persons.
No, my lord.
No means how do you say? The doctor has stated that there is no such injury which can be caused by lathi.
My lord.
Is it the evidence of the doctor who conducted PM?
My lord. I will refer to the page 141, para 8.
Let us see the doctor's evidence. Which doctor?
That is witness number 12, Dr. Santosh Kumar Sahu, in the page 141, para 8.
PW12, doctor. Yes.
141, para 8 of my application.
Crossed injury of left frontoparietal scalp, culminated, communicated.
No, it's we are that is with us. So where he has stated that it can be only possible by sharp cutting weapon, not possible by the lathi. एमती किसी स्टेटमेंट देइछंदी
हां सर पेज सर पीडब्ल्यू 11 भी कहछंदी 12 भी कहछंदी सर 11 12 का को रेफर करछि से कहछंदी आई कैन नॉट से व्हिच वेपन can cause which injuries specifically. It is a fact that wooden lathis are not sharp enough cutting.
No, that is different. Are not here the injury number 1 is caused by hard and blunt object.
My lord.
So lathi is not hard and blunt.
No, that he is telling that it is not.
He is not answering. Your question is not that to the doctor.
ଆପଣଙ୍କର ଯୋଉ PW12 ରେଫର କଲେ PW12 ର ପ୍ରଥମ ସେ ହଉଛି ମୁଁ ଜଣେ ରାମେଲ ଥାପାକୁ ପୋଷ୍ଟମର୍ଟମ କଲି but my esteemed brother is pointing out ରାମେଲ ଥାପାର ପ୍ରଥମ ଇଞ୍ଜୁରିଟା ହଉଛି ଗୋଟେ crossed injury on the left frontoparietal scalp ମୁଣ୍ଡରେ ଯୋଉ ମାଡଟା ହେଇଛି ଏବଂ ତାର ନମ୍ବର ସିଏ କହୁଛି ଯେ ଇଞ୍ଜୁରି ନମ୍ବର 1 so and so combinedly are fatal. Death is due to craniocerebral injury. Head injury is responsible. Injury number 1, mane jo crossed injury, can be caused by hard and blunt object. So that is lathi. So apan kemti कहउचंदी जे नाही डाक्टर एविडेंस रे ओवररूल कर देछि जे कोनोसी लाठी यूज हे तेनु ए जो स्त्री लोक मानकर पार्टिसिपेशन डाउटफुल इन द असॉल्ट ऑफ द डिसीज्ड.
And say
Exhibit 3, 4, 6 and 7 bamboo lathis are having dried of blood stain and mud soaked.
Well, it will come to actually that is not seized from them at any point of time. They have said that the weapons are not given for the actual fingerprints and all these things. That will come afterwards. But here I wanted to say, I'll refer to the PW11, Dr. Vishwaj Joshi, page 135, para 3. Page 135, para 3. In the para, that is 10, except the lathis, wooden sticks, all other weapons are sufficient to cause death to the normal case.
Go para 6.
PW11.
ये रास्ता की कौन का पोस्टमार्टम कला वो दी जन डॉक्टर पीएम रो एग्जाम नहीं चंदी
हां सर ठीक है दी जन डॉक्टर
सॉलाइट दियो के एग्जामिन करछंती तो सेम रिपोर्ट आउथरे प्रमाण है ना ये दी जन कला से 3 जन कला ये काहा को पड़ी PW11 PW11 कला कुन्नू थापा and then he examined out of Kapila Thappa. କେତେ ଅଛି ତାପରେ PW12
11 भी कुछ रामेल थापा और से भी 12 भी रामेल थापा
नहीं ये जो ये कौन रामेल थापा नहीं
रामेल थापा नहीं ना
ନା PW11 କରିଛି ଦି ଜଣକୁ କୁନୁ ଥାପା ଆଉ କପିଲ ଥାପା ଆଉ ଇଏ ଅନ୍ୟମାନଙ୍କୁ କରିଛି ଅନ୍ୟ ତିନିଟାକୁ ବୋଧେ
कुनु थापा और गोटे कला से
କପିଲ ଥାପା
कपिल थापा
ଦୁଇ ସେ ହେଲା ଦୁଇ ଆଉ ବାକି ଜଣକୁ ଇନଜିଓର ଟାକୁ ଦେଖିଛି ସେଟା ହଉଛି ପେଜ ପାରାଗ୍ରାଫ ନମ୍ବର 4 ରେ ବାକି F1 କୁ ଦେଖିକିନି
ଏମାନଙ୍କର ତ ସବୁ ଅଛି ଚପ୍ ଟୁ ନହେଲେ ଇନସାଇଜ ଡୋନ୍ ତେଣୁ ସେଇଥିରେ ଲାଠିର ଚାନ୍ସ ନାହିଁ PW11 ର
ଏଇଟା କିନ୍ତୁ ଏଇ ଯୋଉ
କିନ୍ତୁ 12 ର ଅଛି
PW12 ଯୋଉ ମାନଙ୍କୁ ଏକ୍ସାମିନ କରିଛି ପ୍ରଥମଟା ହେଲା ରାମେଲ ଥାପା ଦ୍ୱିତୀୟଟା ହେଲା
ରାମେଲ ଥାପ୍ପା, ଜଗଦୀଶ ଥାପ୍ପା, ମାଦ୍ରାସୀ ଥାପ୍ପା, କିପାଲା ଥାପ୍ପା, ଟିନୁ ଥାପ୍ପା,
ମାଦ୍ରାସୀ ଥାପା
କିପାଲା ଥାପ୍ପା,
ତାପରେ ଆସିଲା
KIPAL ଥାପ୍ପା, କୁନୁ ଥାପ୍ପା। Informant also eyewitness in this case, my lord. Apart from that, other eyewitness also is there in this case.
But except 7, no other eyewitness.
ମାଦ୍ରାସୀ ଥାପା ଆଚ୍ଛା ଇଏ ତ ଦିଟାକୁ କରିଛି ସିଏ ଦିଟାକୁ କରିଛି ଆଉ ଗୋଟେ ଇଏ କିଏ କରିଛନ୍ତି ଏଇ ଯୋଉ PW12 ଦି ଜଣକୁ ଯାହା କରିଛନ୍ତି ରାମେଲ ଥାପା ଆଉ ମାଡ୍ରାସୀ ଥାପା ଆଉ PW11 କରିଛି କୁନୁ ଥାପା ଆଉ କପିଲ ଥାପା ଆଉ ଗୋଟେ ଡିସିଜ କୁ କିଏ କରିଛି
PW12 का रामेल ଥାପ୍ପା।
ରାମେଲ ମାଡ୍ରାସୀ ଅଛି ଆଉ ଗୋଟେଟା
ଆଉ ଗୋଟେ କୁଆଡେ ହେଲା ରାମେଲ ମାଡ୍ରାସୀ 2 ହେଲା PW12 ଆଉ 11 ହଉଛି କୁନୁ ଆଉ କପିଳ ଆଉ ଗୋଟେ ସେ ଫିଫ୍ଥ ଡିସିଜ ଯିଏ ତା ନାଁଟା ହଉଛି ଜଗଦୀଶ ଥାପା ଜଗଦୀଶ ଥାପାକୁ କିଏ କରିଛି ଦିଟା ଡକ୍ଟର ଏକ୍ସାମିନ ହେଇଛନ୍ତି ଜଗଦୀଶ ଥାପାର କେମିତି ଆସିଲା କିଏ କଲା पंद्रह खंड
Medical officer examined 11 and 12.
15टा ପାରାଗ୍ରାଫ କରିଦେଇଛି ସେଠି କନଫ୍ୟୁଜିଂ ହେଇଯାଉଛି ଗୋଟେ ଡିସିଜ ପାଇଁ ଗୋଟେ ପାରାଗ୍ରାଫରେ ସବୁ ତ ସାରି ଦେଇଥାନ୍ତା
ତାର ହିଁ 15ଟା ଗୋଟେ
Now we are yet to find that who conducted postmortem examination of that Jagdish Thapa. Are you sure that only 2 doctors have been examined in this case?
My lord.
mentioned that 2 doctors, 11
and 2.
Then postmortem report, जोड़ाको exhibit mark ହେଇଛି inquest report ଅଛି ଜଗଦୀଶ ର exhibit P/7 ତାହେଲେ ତାର ଇଏଟା ପଡିଗଲା postmortem report. You come to page number 73 ସେ ଯୋଉଟା ଅଛି ସେଇଥିରେ trial court judgment ର ତା ଦେହରେ ଲେଖା ହେଇଛି PM report. ନା ତା PM report mark ହେଇନି ବୋଧେ inquest report mark ହେଇଛି PM PW12 ହେଲା ରମେଲ ଆଉ ହଉଛି
ମାଡ୍ରାସି
ତିନି ଜଣ
ଆଉ ଗୋଟେ କାଇଁ
ଆଉ ଗୋଟେ
PW12 is Ramel Sappa, my lord, para 1. Next, my lord, 4, para 4, my lord.
ମାଡ୍ରାସି
Madras, my lord.
ତାପରେ
Next, my lord, para 7.
ଏଟା injured ଟା
PM against the report of deceased Ramel Sappa.
ହଁ ଫେର ସେଇଟା ରିପିଟ କରୁଛୁ ସେ
we are asking you who conducted the PM examination of Jagdish Thapa. କାରଣ ସେଇ ଜଜମେଣ୍ଟ ରେ ମଧ୍ୟ ତାର ଇଏଟା ମାର୍କ ହେଇନି ଯୋଉ PM ରିପୋର୍ଟ ଟା ମାର୍କ ହେଇନି କିନ୍ତୁ ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟ ଟା ମାର୍କ ହେଇଛି ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟ ହଉଛି exhibit 7/1 that is in page number 73. Exhibit P7/1 is the inquest report of deceased Jagdish Thapa. ମାର୍କ ହେଇନି ଆଉ ଅଛି ପେଜ ଅଛି ଲାଷ୍ଟ କୁ ଲେଖା ହେଇଛି ପୋଷ୍ଟମର୍ଟମ ରିପୋର୍ଟ ନା ଏଇଥିରେ ପୋଷ୍ଟମର୍ଟମ ରିପୋର୍ଟ ଅଛି ଜଗଦୀଶ ର କିଛି ମାର୍କ ହେଇନି ସେମିତି ଛଡା ହେଇଯାଇଛି who has conducted it S.R.Sahoo Dr. S.R.Sahoo କିଏ ଗୋଟେ କଣ୍ଡକ୍ଟ କରିଛି Dr. S.R.Sahoo ଏକ୍ସାମିନ ହେଇନି ହଁ ସନ୍ତୋଷ କୁମାର ଏଟା SR ନା SK SK ହେଇଥିବ କି SR କଣ
ସନ୍ତୋଷ କୁମାର ଡକ୍ଟର ସନ୍ତୋଷ କୁମାର ସାହୁ ଏଇ ଯୋଉ ପୋଷ୍ଟମର୍ଟମ ରିପୋର୍ଟ ସାଇନ କରିଛି କିଏ ସାଇନ କରିଛି ତାକୁ କିଏ SR ସାହୁ
Evidence really,
ଏଟା SR ସାହୁ
the only said that on that day I received the PM report of Jagdish Thapa. But that is not in my
ଏଟା କେବେ ହେଲା ଆଉ ଗୋଟେ କୋଉ ହସ୍ପିଟାଲରେ ପୋଷ୍ଟମର୍ଟମ ହଉଛି 14/7/2013 14/7/2013 ସେ ଯୋଉ PW 11-12 କେବେ କରିଛନ୍ତି ଦେଖି 11-12 14/7/2013 ତ ଠିକ ଅଛି ସେଟା ଆଉ ଏମାନେ ହଁ ସବୁ ଗୁଡାକ 14/7/2013 ସେ ଯୋଉ ଆଙ୍କର ପୋଷ୍ଟମର୍ଟମ ରିପୋର୍ଟଟା ଦେଖିବି ତା ସିଗ୍ନେଚର ବି ଜଣା ପଡିବ। S.R. Sahoo ହେଲା ଏକ୍ଜିବିଟ୍ 18 ଏକ୍ଜିବିଟ୍ 18 ଟା ବାହାର ନାଇଁ ଏକ୍ଜିବିଟ୍ ବାହାର ଏକ୍ଜିବିଟ୍ 18
My lord, can I draw your attention to page 164 of my writ application, where the PW14 Deepak Kumar Jena IIC has given. Here specifically said the fingerprint.
ଆପଣ କଣ ବୁଝୁଛନ୍ତି ନା କୁଆଡେ ଆପଣ ଅଛନ୍ତି କଣ ଏଠି ଡିସ୍କସନ କଣ ଚାଲିଛି ଆପଣ ଫିଙ୍ଗରପ୍ରିଣ୍ଟ କଣ ଦେଖଉଛନ୍ତି?
दस कोटा सर संतोष से पूरा लिखिଛନ୍ତି सिग्नेचर टा संतोष पूरा ଅଛି
संतोष कुमार
संतोष कुमार
he's some other doctor.
How is that he left? अच्छा जजमेंट में से दे एग्जिबिट
तो मिस्टर दास ये जो लेडी टा जो ब्लाइंड अच्छी तार जो गोटे ब्लाइंडनेस सर्टिफिकेट देइछंती ता विषय आपण इंस्ट्रक्शन आनो देखियो कोन से जाय
মানে जगदीश रमेला
हां
पोस्टमार्टम टा जे करछन एसके साहू
ये सेटा
एसआर साहू
एसके साहू
ये वाला एसके साहू
ये अलगा डॉक्टर दस्तखत भी देख साइड अलगा সেটা প্রমাণ করেই না দিও পোস্টমর্টম রিপোর্ট প্রমাণ হয়নি
এক্সিবিট এটা অলগা আছে
না এক্সিবিট লিস্ট আমি দেখছি
নাই পুরা এক্সিবিট
যেটা লাস্ট আছে অলগা এক্সিবিট অলগা মানে
হাউ সেপারেট আছে সেইଥିପାଇଁ ସେପାରେଟ ଅଛି ଯେହେତୁ ମାର୍କ ହେଇନି ଏକ୍ସିବିଟ ସେପାରେଟ ଅଛି ଆଉ ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟଟା ମଧ୍ୟ ହେଇଯାଇଛି ତାକୁ ଜଜମେଣ୍ଟରେ ଦେଖନ୍ତୁ ଯେ କାହିଁକି ସେ ଡାକ୍ତର ଏକ୍ସାମିନ ହେଲାନି ଆଉ ଯଦି ବି ଏକ୍ସାମିନ ହେଲାନି ତାକୁ ମାର୍କ କଲେନି କେମିତି ମାର୍କ ଯଦି ନ କରିବ ଟୋଟାଲ କିଛି ଆସିଲାନି
homicidal nature of death is established.
ପ୍ରମାଣ କରିବେ homicidal death otherwise it could have been suppose ସେ ଡକ୍ଟର ଆସି ପାରିଲାନି ତାର ଅଛି ୱେ ଆଉଟ୍ ଅଛି ପ୍ରମାଣ କରିବାକୁ এটা পুরা রেকর্ড বাহারিকিনি বর্তমান রয়েছে মানে সেপারেটলি ইজ নট ইন দ পার্ট এন্ড পার্সেল অফ দ এক্সিবিট রাইট তারপরে এই যে আনেক্সর 4 টাকু দেখুন তার মেন যে অপিল মেমোরে जोटा देइछंती इट्स अ ब्लाइंड डिसेबिलिटी सर्टिफिकेट लिखछंती 100% ब्लाइंड बोली बोथ आईज देखछंती so you take instruction about that we see that
because this has been issued only on 13 January 2023 and if she is a blind since beginning she must have this certificate earlier also jail authority भी mention करथिबे तांकर
ঘটনাটা কেবে লাগি
14/7/2013
so if this certificate is correct that means at the time of occurrence she was completely blind she was completely blind
that is
13/1/2023 रो
so this suggestion was ever given that she is a blind
এটা আধার কার্ড ପାଇଁ এই ଡକ୍ୟୁମେଣ୍ଟ ପ୍ରିପେୟାର ହେଇଛି ଦେଖନ୍ତୁ ଦେଖନ୍ତୁ ଆନେକ୍ସଚର 4 ରେ बुझिले annexure 4 रे come to page number 169 169 देखो तो the applicant has submitted the following document as proof of residence. Nature of document होची आधार कार्ड पे डॉक्यूमेंट से आनी देइछि 13/1/2023 रे लेखुछन 100% ब्लाइंड इन बोथ दी आईज देखिले तो जो लेखा ए बी सी सी हला तेणु जदि 100% ब्लाइंड हला ए रिपोर्टर जदि ऑथेंटिक गोटे रिपोर्ट हला then this occurrence has taken place in July 2023
13
July 2013
13 ना
13
the 13 the plea was consistent plea नहीं थे ना this is blind and she could not have seen
এটা 2023
এটা 2023 रा तो after he is blind
after the incident maybe
after the incident
on which date he was
right seen
so it was from the childhood or it was
then it's later so after the occurrence he was blind also IN number, this is CRL number 384 of 24, IN number 958 of 2024. There is an application for bail. The learning counsel for the petitioners submitted that all the petitioners are ladies and petitioner number 1 is aged about 69 years and petitioner number 4 is a blind lady. In support of such contention, a disability certificate has been annexed to the appeal memo by the annexure 4. The land counsel for the state seeks some time to obtain instruction regarding the health condition of this apparent number, petitioner number 1, Srimati Iyafulo Maji, and petition number 4, Srimati Indu Maji. The concerned jail superintendent, medical officer, I'm so out of this matter, what is up top? Yes.
This is last item here. 516 of 2024.
Yeah.
Here also that as on the date of occurrence, the appellant was aged about 64 years. Along with my matter, my senior Deepali Mapti, and he was last and directed and counsel for state to take each section with regard to that age and.
No, you are not on bail.
No, I'm throughout in custody. From 10 years.
Custody since 2004 last item रो अच्छा एटा जो आनी में ना एटा तांग क्लास रे तो custody certificate मधे नहीं है यार custody certificate आना तो item number last item जो था 516 custody certificate है ना और health condition में है here
repeat with that
please
आपण व्हेरीफाई करण्यासाठी
कोटा करले तांकर ये डाउट 152 of 24 अछि ना बेल
स्टे दोइटा
प्रेम थापा तो
suspension of sentence आया
प्रेम थापा अछि तो
1252 verse
1252
for suspension of sentence and for bail.
Allah. Yes.
Item 42.
ପାଠାଡ଼ ବୋଲି ଅଛି ତିନିଟା କଣ କହୁଥିଲେ
ସେ ଟିକେ ମାନେ ଆଜି
ଅସୁବିଧା Yeah.
How much?
Good.
Not sure it is.
Okay. What is বুঝলি একদম ঠিক আছে জানছি ঠিক আছে জান দেখতে সেম আচ্ছা আচ্ছা EW3 perhaps is an eyewitness.
Yes, my lord.
Sushila Kuju.
Yes, my lord. She is a sole eyewitness. At her house, incident occurred.
You place the FIR first, then.
Yes, my lord. हाँ सर लिखित आंकड़ा अभिप्राय यही कि जे ମୁଁ ରଞ୍ଜିତ କୁଲୁ ମାନେ she was my lord, he is my lord PW1 in the witness my lord. ରଞ୍ଜିତ କୁଲୁ ପିତା ଇବାରେ ଶସ୍ତ୍ର କୁଲୁ ଗ୍ରାମ ସୋନସ ଫୋନରେ ଅବଗତ ହେଲି ଯେ ମୋର ବଡ ଭାଇ ପ୍ରଦୀପ କୁଲୁ ଆଲିଆ ଦୀପୁ ଯିଏକି ହଠାତ୍ yes my lord ଏକ ଯିଏକି ହଠାତ୍ ଦୁଜାଡ ବସ୍ତି ଛେନରେ ରହୁଥିଲେ ଗତକାଲି ସନ୍ଧ୍ୟା 9ଟାରୁ 10 ଘଟିକା ମଧ୍ୟରେ ଶ୍ରୀମତୀ ସୁଶୀଳା କୁଜୁ ମାନେ PW3 yes my lord
Eyewitness.
yes my witness ସ୍ୱାମୀ ନିରଞ୍ଜନ ମହାପାତ୍ର ଘରେ ଖାଇବାକୁ ବସିଥିବା ସମୟରେ ସେଜୁ ହଠାତ୍ ବସ୍ତିରେ ସେଇ ହଠାତ୍ ବସ୍ତିର ଏତୁଆ ମୁଣ୍ଡାର ନାମକ ଯୁବକ ମୋର ବଡ ଭାଇକୁ କୌଣସି ଅସ୍ତ୍ର ଦ୍ୱାରା ମାରଣାତ୍ମକ ଆକ୍ରମଣ କରିଥିଲା ସେଇ ବସ୍ତିର ଲୋକମାନେ ମୋର ବଡ ଭାଇକୁ RGH କୁ ଚିକିତ୍ସା ପାଇଁ ନେଇଥିଲେ କିନ୍ତୁ ଚିକିତ୍ସା ହେଉଥିବା ଅବସ୍ଥାରେ ରାତ୍ରି ପ୍ରାୟ 11ଟା ପରେ ମୋର ବଡ ଭାଇର ମୃତ୍ୟୁବରଣ କରିଛନ୍ତି ମୁଁ ଆଜି RGH କୁ ଯାଇ ମୋର ବଡ ଭାଇଙ୍କର ମର ଶରୀରକୁ ଦେଖି ସତ୍ୟ ଘଟଣା ବୋଲି ଜାଣିପାରିଲି ତେଣୁ ଉପଯୁକ୍ତ ତଦନ୍ତ କରି ଦୋଷୀ ବିରୁଦ୍ଧରେ ଆଇନ ଅନୁସାରେ ବିହିତ କାର୍ଯ୍ୟାନୁଷ୍ଠାନ କରାଯାଉ.
So only charge was 302.
Yes, my lord.
Come to straight to PW3, the eyewitness, only sole eyewitness.
Yes, my lord, PW3. May?
Yes.
I know the accused Bhatka who belongs to my basti. I know this is Pradeep, alias Deepu, who addressed me
as Didi. I do not know the informant. Occurrence took place on 3/10/2016 at about 9 p.m. in my house. At that time, myself and Dipu were present in my house. At about 9 p.m., accused entered into my house. By then, Dipu was about to take his dinner. Accused shouted at Dipu that he would assault him, as he had declared him as a thief of him. He suddenly assaulted Dipu by means of a stick at his head. He inflicted about 10 to 15 blows at the head of Dipu by means of that stick. Dipu sustained bleeding injuries at his head and he fell down on the ground. When I tried to intervene, accused threatened me to assault if I made any shout. In fear, I did not intervene. One Chandan has seen the occurrence standing in front of my house and he shouted. Other Basti, Chandan has not been examined. Other Basti people arrived at my house and we shifted Dipu to Raurkela Government Hospital, Raurkela by an auto. At about 12 midnight, Dipu died at hospital during his treatment. I have been examined by police in connection with this case. This is the stick by which accused assaulted Dipu at his head, causing injuries, and the same is marked as MO1, cross-examination by defense. I had married to another person earlier, but I left him and I resided with Niranjan Mahapatra since then. Yes, my lord. Niranjan Mahapatra has not also been examined. Dipu was regularly coming to my house for his meals. It is not a fact that accused did not come to my house 9 p.m. of the occurrence day. It is not a fact that Dipu attempted to commit rape on me and with association of other people I killed him and falsely implicated others as the killer of Dipu. I cannot say the registered number of the auto in which Dipu was taken to the hospital. At the time of occurrence, accused had put on a t-shirt and a knicker. On the next day, police has examined me. I have shown MO1 to police. My sari was stained with blood when I shifted Dipu to hospital. Police has not seized my blood-stained sari. It is not a fact that accused did not come to my house on that day and that he has not assaulted Dipu, nor killed him. That the instance of Basti people, I am deposing falsehood.
Now, doctor?
Dr. Mal PW8.
What are some difficulty?
This is homicide, it is very clear comes out on the
No, about the number of blows we assessed.
15.
That is also there in that PM report.
Yes, sir, almost there. Because only the vital part of the that is that to head. Sabuda head. Head and nack about here, my lord, homicidal part cannot be denied. But whether this appellant has committed the crime, that's the vital point. PW3 was in circumstances because the instance of the other witnesses are here. Those names have been mentioned in the at the time of 161 my lord.
ସେ ଗୋଟାକ ତ ଭାଙ୍ଗି ପାରିଲେନି ଆଉ ଘର ଭିତରେ ଘଟଣା ହେଇଛି ତା ଘର ଭିତରୁ ସେଗୁଡାକ ସବୁ ରିକଭରି ବି ହେଇଛି ଆଇଓ ନିଶ୍ଚୟ ବ୍ଲଡ ଷ୍ଟାଣ୍ଡ କରିକା ସବୁ ସେଇଠୁ ପାଇଥିବ
fallacies there is doubt because whether this man has perpetrated the crime or not, that has to be my lord's judgments are there.
We are certain to the eyewitness evidence. When eyewitness is there,
yes,
so I visited the spot. आगे पढ़े आसन PW8 रो एविडेंस.
Yes, ma'am. PW8.
तीनिटा लेफ्ट फ्रंट पैराइटल लैसरेटेड वुंड गोटाक देखछन साइज गोटाक बोन डीप गला सातटा आउ स्टिच पड़ी से सब गुडा मुंड आउ
वाइटल पार्ट
जो प्रकार मार ହେଇଛି ସେ ମୁଣ୍ଡର ଅବସ୍ଥା କଣ ଥିବ ମାନେ cause of death was due to coma to head injury. On removal of hematoma, open fracture of the skull is there. On opening the skull bones, brain matter, so and so were found. Nasal bone was completely fractured into small pieces.
Small pieces.
एकदम indiscriminate.
Indiscriminately पूरा focus करी मारी ସବୁ दବ मुंडो और एरिया रे
आग पछ मुह सब
ସବୁ बाकी आईओ रो यदि आसीबे आईओ एविडेंस कुछ जो स्पॉट विजिट कला.
But the statement was given to the court after 6 months, 4 months of occurrence.
I conducted the inquest over the dead body of the deceased. RGS को जाइतला. अच्छा. I sent the dead body, then I examined so on, so I visited the spot along with the scientific. In course of my spot visit report a crime drill exhibit 11. Exhibit 11 that you have done.
to close the actually. Rob's case things.
Spot map wrong, जोटा mark ହେଇଛି spot visit report that is marked as exhibit 8.
Yes, ma'am.
तारो page number 3 को पढ़े आसंतु माने third page रे जोटी about the spot होची भी रे बाहर कर दियंतु सेटा. That is exhibit 8. Spot visit report with exhibit 8. Exhibit को बाहर पढ़े आसंतु
79.
List of exhibit रे exhibit 8 को पढ़े आसंतु ऊपर नंबर लिखा है exhibit 8.
It's नहीं, ये तो exhibit with कुछ. Exhibit with कुछ.
Page 57 was
it. 79 start. 70 आपको लगी?
पहले.
ठीक है, एरिया पर any third page, तो
Serially अशी.
Yes, madam, we got it. Exhibit 8.
Exhibit 8. Now you come to the third page about the spot.
Yes, madam.
Roman B.
Roman B. Yes, madam.
ମାନେ ସେଟା ହଉଛି 10 ନମ୍ବର ରୋମାନ ବି ହେଲା 10 ନମ୍ବର ରୋମାନ ବି ଦେଖନ୍ତୁ କଣ ଲେଖିଛନ୍ତି. Spot is located so and so main road ଛାଡନ୍ତୁ.
Yes, ma'am.
Spot house was a mod house with brick wall, asbestos wall so and so.
Yes, ma'am.
Octopus one is so and so. Entrance door having a pool of blood was found to be lying at the entrance room.
Yes.
Which the incidents was occurred. A small wooden stool was available so and so. Size of the room so and so. As page 5. तापरे फिजिकल क्यूज एवढा सब मिलिला सेठी तारो वॉल रे ब्लड स्टेन.
Yes.
सो जो स्पॉट रा माने डिस्प्यूट करिवा को किछि स्कोप ही नाही माने सेठी ड्राई देखंतु बांबू स्टिक टा पडिछि सेठी.
Yes, ma'am.
रो एच रे पडिछि.
Yes, ma'am.
गोटे आयरन रड पडिछि सेटा भी ब्लड अछि. ब्लड स्टेन गामुछा पडिछि तेनु तापरे ତା ଯୋଉ ଇଏ ସ୍କେଚ ମ୍ୟାପ ଟା ଦେଇଛି ତା ତଳେ ଅଛି ଠିକ ତାର
sketch pad
ରିପୋର୍ଟରେ pool of blood ଲେଖିଛି କୋଉଠି ପଡିଛି
yes ma'am good
ବାଡିଟେ ବି ସେଇଟା ପଡିଛି ନା କଣ?
ବାଡିଟା ପଡିଛି ବାଡିଟା ଦେଖି ଛୋଟ ହେଡିଂ ରେ ଲେଖା ହେଇଛି ଯେ ଇନଫରମେସନ ଆସିଲା ଯେ ସୁଶୀଲା ଯୋଉ ୟାର PW3 while he was taking dinner in the house of so and so ଏଇଠୁ ଆସିଲା ଆଟାକ୍ କଲା ଏଇଟା ବ୍ରିଫ ହିଷ୍ଟ୍ରି ଅଫ ଦି କେସ୍ ଲେଖା ହେଇଛି ତାପରେ ସେ ସ୍ପଟ ଭିଜିଟ କରିବାକୁ ପ୍ରଥମେ ଆଗେ ଏଠିକି ପଳେଇଲା RGS କୁ ଗଲା ସେଠି ସେ ଇନକ୍ୱେଷ୍ଟ କରିବା କରିଦେଲା ପରେ ତାପରେ ଆସିଲା ସ୍ପଟ କୁ ତେଣୁ ସେ ସେଇ ଅନୁଯାୟୀ ସିରିୟଲି କରି ଲେଖା ହେଇଛି second page ଅଛି note below proceeded to the scene of crime after inspection of the dead body of the deceased in order to collect the physical clue materials ହେଲା ସେଟା spot visit proof ର page ର 2 ର ସବା ତଳେ ଲେଖା ହେଇଛି ମେଡିକାଲ କାମ ସରିଲା ପରେ ତାପରେ ସିଏ scene of crime କୁ ଗଲା inspection ପାଇଁ note below ଲେଖା ହେଇଛି ତାପରେ ଆସିଲା ଯୋଉ page ଟା ଆପଣ ପଢୁଥିଲେ about the spot So, eyewitness PW3
161 fully corroborated.
That is not second in the cross examination. And that lady, after seeing the assault, made a call to that informant. That is also mentioned in the FIR. Je mu yari to cover paili. If you come to
informant
the
no, that information he gathered from his cousin. PW2.
Please come to
he PW3
ଏତେ ଲାଗୁ ପଳେଇ ଆସନ୍ତୁ 1 ନମ୍ବର ସାକ୍ଷୀ କହୁଛନ୍ତି ଯେ ଗତକାଲି ସନ୍ଧ୍ୟା 1:15 ମଧ୍ୟରେ ଶ୍ରୀମତୀ ସୁଶୀଲା କୁଜୁ ଘରେ ସୁଶୀଲା କୁଜୁ ହଉଛି PW3 ଘରେ ଖାଇବାକୁ ବସିଥିଲା ସମୟରେ ସେଇ ବସ୍ତିର ଏତୁଆମ 1:15 ଯୁବକ ମୋର ବଡ ଭାଇ କୌଣସି ଅସ୍ତ୍ର ଦ୍ୱାରା ମାର ସେଇ ବସ୍ତିର ଲୋକମାନେ ମୋର ବଡ ଭାଇକୁ RGH ହସ୍ପିଟାଲ ଶୁଣି କିନ୍ତୁ ଚିକିତ୍ସା ହଉଥିବା ସମୟରେ 1:15 ମୃତ୍ୟୁବରଣ କଲା ମୁଁ ଆଜି RGH କୁ ଯାଇ ମୋର ବଡ ଭାଇଙ୍କର ମୃତ୍ୟୁ ଦେଖି ଆଚ୍ଛା ସୋ ଫୋନରେ ଗୋଟେ ଗୋଟେ ପୁରା ଅବଗତ ହେଲି ଏଇଠି ତ
see PW3 no another person is there man PW my lord is also right my lord PW2 yes it was
somebody
yes my lord that is
this occurrence has taken place in the
house of Securitization.
Yes man
and that is so medical evidence corroborates ocular evidence spot visit note also that indicate that was the spot
yes
so many things say jo lathi blood stain ye eguda sabu seitu hi milichi
161 is also consistent with the evidence exactly ditto 10 to 15 15 10 ଥର ବାଡିବାରୁ ବେହୋସ ହୋଇ ମୁହଁ ମାଡି ତଳେ ପଡିଗଲା ବହୁତ ରକ୍ତ ବାହାରିଲା ଏହା ଦେଖି ବଡକୁ ପଳାଇ ଯାଇଥିଲା ମାରପିଟ କଲା ବେଳେ ମୋର ହାଲା ହୁଲା ଶୁଣି ପାଖ ଘର ଚନ୍ଦନ ବୋଲି ଗୋଟେ ପିଲା ପାଖରୁ
ତ ତା ଘରେ ଯେତେବେଳେ ହେଇଛି he is the best witness to say
yes
and she has stated down nothing has been brought out in the cross examination ଗୋଟେ କଣ ସଜେସନ ଦେଇଛନ୍ତି ସେ ଆଟେମ୍ପ୍ଟ କରୁଥିଲା ରେପ୍ କରିବାକୁ ତେଣୁ ସେ ଇଏ ମାରିଦେଲା ଦ୍ୟାଟ୍ ଇଜ ନଥିଙ୍ଗ
fallacious investigation ଆସୁଛି why I'm saying this because ଦିଟା weapon of offense ଅଛି ଗୋଟେ iron rod ଅଛି ଆଉ ଗୋଟେ stick ଅଛି
ମାଡଟା ହେଇଛି ଆଦେର ସେଠି ଆଇରନ୍ ରଡ୍ ଟା ହୁଏତ ପଡିଥିବ ସେଟା ତା ଉପରେ
blood ପଡିଛି yes my lord
that is not that iron nobody's case is that iron rod assault ହେଇଛି assault ହେଇଛି stick ତେଣୁ stick ଯେତେବେଳେ assault ହେଇଛି ଯେତେବେଳେ ରକ୍ତ ପଡିଥିବ ସେଟା ଆଉ ସେ ଗୋଟେ ଜାଗାରେ କନଷ୍ଟାଣ୍ଟ ହେଇନଥିବ ଯେତେବେଳେ ପଡିଥିବ ଯାହା ସେଠି ଇଭେନ୍ ଇଫ୍ ସେଇ ଯୋଉ ୱାଲ୍ ରକ୍ତ ପଡିଛି ତଳେ ରକ୍ତ ପଡିଛି ସେଇଠି ହୁଏତ ସେ ଆଇରନ୍ ରଡ୍ ଟା ପଡିଯାଇଥିବ
ଫିଙ୍ଗର ପ୍ରିଣ୍ଟ ବି ଆସିବା ଷ୍ଟିକ୍ ଯୋଉ ଷ୍ଟିକ୍ ମାରିଲି ଫିଙ୍ଗର ପ୍ରିଣ୍ଟ ଆମର ଆସିବା କଥା ଆଟଲିଷ୍ଟ
circumstantial evidence fingerprint ଆସିଲା direct ସେ ଆସିଲା
ଆମେ demolish କରିପାରୁନୁ
it is the demolition ଆଉ corroborated by the medical evidence ସିଏ ବି ଦେଖୁଛନ୍ତି କେତେ ଯୋଉ ବ୍ଲୋ ହେଇଛି ସେତିକି ବ୍ଲୋ ଦେଖି ଯାଆନ୍ତି ତାପରେ ଇଣ୍ଟେନସନ ପୁରା ଆସି ଯୋଉ ପାର୍ଟ କୁ ମାରିଛନ୍ତି ଆଉ କୌଣସି ପାର୍ଟ ରେ ଅନ୍ୟ ମେଡିକାଲ ଏଭିଡେନ୍ସ କହିଦଉଛି ଆଉ କୌଣସି ଇଏରେ ଇଞ୍ଜୁରି ହେଇନାହିଁ ତେଣୁ ୟୋର ଫୋକସ ଇଜ ଅନ୍ ଦ୍ୟାଟ୍ ଭେରି ପାର୍ଟ
ତାଠୁ ମୋଟିଭ ଇଣ୍ଟେନ୍ସନ ପାର୍ଟ ଇଜ ଅଲସୋ ଗୋଟେ କୁକୁଡ଼ା ପାଇଁ ଚୋର କହିବା ପରେ
କଣ ହେଇପାରେ
that has been created because why I'm saying this 2016 October 2016 incident but the statement of the present PW3 was given to the court to the 17th January.
No, 161 टा immediately record ହେଇଥିବ ବୋଧେ 161
document ଦେଇନାହାନ୍ତି
no
but that is there in the judgment
ସେ ପହଞ୍ଚିକି ପୁରା ପ୍ରଥମେ ତାକୁ ଏକ୍ସାମିନ କଲା paragraph 4 ର IO ର ଏଭିଡେନ୍ସ ହଉଛି when
4/16 ସେ ଏକ୍ସାମିନ ହେଇଛି
why I'm saying this ଗୋଟେ document court submit କଲି ଗୋଟିଏ document particular vital witness document I have not submitted to the court
which one
that PW3
no it is there that's your signature is there on 5th
but my judgment also it has been reflected
no
that is one of the ground in the
ଦେଖୁଛନ୍ତି ଆପଣ ସେଠି ଅଛି ଯେ ଦେଖନ୍ତୁ କେସ୍ ଡାଏରୀ ଥିବ କେସ୍ ଡାଏରୀ ଦେଖି ଦିଅନ୍ତୁ ସେ
5, 10, 16 ନା ଦେଖିଦେବେ
କେସ୍ ଡାଏରୀର ଆପଣ ଯୋଉ ଓଡିଆ ଷ୍ଟେଟମେଣ୍ଟ ଗୁଡା ଅଛି ନା ଇଂଲିଶ ଛାଡି ଦିଅନ୍ତୁ ତାପରେ ଯୋଉଠି ଓଡିଆ ଷ୍ଟେଟମେଣ୍ଟ ଗୁଡାକ ଅଛି 161 କୋଡ ପେଜରେ ଅଛି ଯୋଉଟା
LCR statement
ଏଗୁଡା ଦେଖନ୍ତୁ ଜଜମେଣ୍ଟ ତଳେ ଲେଖା ହେଇଛି ଷ୍ଟେଟମେଣ୍ଟ
ଠିକ ଜଜମେଣ୍ଟ ତଳେ
ଜଜମେଣ୍ଟ ସେଠି ଦେଖନ୍ତୁ LCR Now you come to that ପ୍ରଥମ ଷ୍ଟେଟମେଣ୍ଟ ହଉଛି ସୁଶୀଲା କୁଜୁର ସୁଶୀଲା କୁଜୁର
ରାଇଟ ସାଇଡ୍ ରେ ଉପରେ କେତେ ନମ୍ବର
it is 14 like
ଆଇର ଷ୍ଟେଟମେଣ୍ଟ ହଉଛି ପୁରା ସେଇଆ
another point
3 ମାସ ପରେ ରେକର୍ଡ ହେଲା କୋଉଠି ପାଇଲେ
3 ମାସ କାହିଁକି ଆସିଲା ଏଇ କଥାଟା ମୁଁ ଡକ୍ୟୁମେଣ୍ଟ କୋର୍ଟକୁ ପ୍ରୋଡ୍ୟୁସ କରୁଛି ଯଦି that document was with me I could have produced the same before the court
which document
this 161 statement
no 161 was sent immediately it was sent immediately
it was produced before the it must have been a FIR or ESI
from the ପଠାବି ହୁଏନି ଆମେ
right
on 5th it has been sent the very next day
who has taken note of those aspects
who else could take it SDGM is the right person
here my lord ଖାଲି assist କରିବେ
FIR ଦେଖନ୍ତୁ FIR ଯୋଉ ଦିନ ପଠା ହେଇଛି FIR ହଉଛି 4th October କୋର୍ଟରେ ପହଞ୍ଚିଛି 5/10 ରେ ସେଇ ଦିନ 161 ଯାଇଛି ତେଣୁ ପରେ କ୍ରିଏଟ ହବା ସିଏ that is no any other submission
my lord my lord I'm just wanted to bring my lord attention only but I have not gone to judgment I have not mentioned entire judgment that is page 13 that is what our argument before the learned court below page 13 mail internal page 13 mail of the judgment there one observation that start paragraph 24
page
13 mail paragraph 24 it starts on page 12 in the instant case it has already been held that on the date and the time of occurrence both the deceased and PW3 were present inside the spot house. From the evidence of PW5, it appears that when she reached the house of PW3, such PW3 immediately disclosed before her that the accused assaulted the deceased. Therefore, it cannot be said that PW3 has not disclosed the incident. The incident in the present case has taken place in Basti, and all the independent witnesses who are residents of said Basti have deposed that on hearing human cry.
এটা তার কন্ডক্ট আসুଛି ନା ଏଭିଡେନ୍ସ ଆକ୍ଟ ର ସେକ୍ସନ 6 ରେ ଦ୍ୟାଟ ଇଜ ଅଲସୋ ଆଡମିଟ୍ ସେ ଦେଖିକିନି ସମସ୍ତେ ଯିଏ ପହଞ୍ଚନ୍ତି କେବଳ ଆକ୍ୟୁଜ ନାହିଁ କହୁଛି ସେଇ ମାରଲା.
Yes, ma'am. Thereafter, and that they found the deceased lying with the bleeding injuries. Furthermore, the IO was suggested that since the statement of the witness were not existent till 7/1/2017.
That is a wrong one. That is a wrong.
ସଜେସନ କଣ ଦେଇପାରନ୍ତି ଅଲଗା କଥା.
Yes, suggestion could be anything. But the IO stated, the IO in course of his examination, because that 4/10/2016, the FIR in connection.
Registered, he took up the investigation. On the same day he examined
161.
ତା ପରଦିନ କୋର୍ଟରେ ପହଞ୍ଚିଛି statement.
So that is the court letter has also said that the defense has merely making a bald suggestion that the statement of the witnesses were not in existence on 7/1. So till 7/1/17. Where from they got it?
My only anxiety, unerringly, it must point out towards.
No, there is no question of unerring here. Here it is eyewitness account. Unerringly, point guilt can only be deduced in a circumstantial evidence.
Yes, ma'am.
Here it is eyewitness account.
And the medical evidence, because one person will be.
That suggestion which has been given to the IO, it's like this, paragraph 16. ସେ କହୁଛନ୍ତି paragraph 16 ଏଣ୍ଟାୟାର ପଢନ୍ତୁ ସେଟା ୟା ପାଇଁ ସଜେସନ ଦିଆହେଇଛି ଏ ଯୋଉ ୱିଟନେସ୍ ମାନଙ୍କର ଷ୍ଟେଟମେଣ୍ଟ ପାଇଁ ଦିଆହେଇଛି.
Yes.
It is not a fact that I had manipulated and manufactured the statement of the witnesses for which it was forwarded to the court on 7/1/2017. It is not in respect of that PW3. PW3 ର statement, in fact, 5/1
5/10 ର incident 5/10 It is in respect to other witnesses.
I had manipulated, manufactured the statement of witness for which it was forwarded to court on 7/1/2017.
Not a fact.
And other things. That eyewitness part, that part judgments are against me also, because that has to be trusted. But my point is here, the medical examiner, the person will be confident entire of life, 20 years boy, and that too, whether he only for small issue regarding hen was stolen, for which he went to the house of the.
That we cannot say. See,
it's a different matter. ଗୋଟେ ଲୋକଟାକୁ ଆପଣ 10-12ଟା ପୁଣି ଆଉ କୋଉ ଜାଗା ନାହିଁ.
But doubt should be clear.
The intention is very clear from the nature of blows given, the impact it has caused. ଆଉ କଣ ଦରକାର?
Oh, you say about the trivial nature of allegation. See, in people of that strata, even 5 rupees counts, you know. If they have a credit of only 5 rupees and they did not return, there could be a murder.
କୁକୁଡ଼ା ପାଇଁ ସଜନା ଇଏ ପାଇଁ କେତେ ମାନେ ଏବଂ କେବଳ ଇଏ କରିବେନି ପୁରା ମୁଣ୍ଡ ଧରିକି କାଟିକିନି ମଧ୍ୟ ପଳେଇବେ ଥାନାକୁ. ଏମିତି ମଧ୍ୟ ଡ୍ରାଇଭର ପିପୁଲ ସେ ସବୁ that is common.
ତାପରେ ଯୋଉ ୱିଟନେସ୍ ତା ପରେ ବି ଅକରେନ୍ସ ସେତେବେଳେ ଦେଇଥିଲେ ସେମାନେ statement is not also clear.
That is also not important.
Statement is the vital on the basis of which the person.
That is also not important because this witness has not been sacked.
Yes.
Had this witness been given a prevaricating statement, then probably you could have.
Yes, ma'am. That I cannot deny. That part has not come out. And the thing is here, my lord, at least at the time of examination, I also could have made an effort to find out whether this man is a real culprit or somebody else. So when the integrity, one person will come and say that this person committed the crime. But on the basis of this person will commit
the person is very much identified, named promptly, FIR has been lodged with promptitude. Why the IO will go in search of a third person?
The FIR was lodged next day, not the same day.
No, 4th day. On 4th.
Third incident occurred, 4th FIR was.
Yes, my lord.
Then FIR was lodged.
ତାକୁ ସେମାନେ ଆରଜିଏସ୍ କୁ ନେଇଗଲେ ତାପରେ ଇଏ ହେଲା ପରେ ଇଏ ଖବର ଦେଇକି ଇଏ ଶୁଣିକିନି ଆସିଲା ତା ସାନ ଭାଇ ଯିଏ PW1 ରଞ୍ଜିତ ତାପରେ ସେ ଏତଲା ହଁ କଣ କହିବେ ମିସ୍ ସାହୁ? Anything you want to say? And so it does, and this is Sushma Rani Sahu giving this close to okay, ଅଛନ୍ତି ରେଡି କରନ୍ତୁ କାଲି ଆଉ ଗୋଟେ ନବା ତାର ନାହିଁ
କାଲି ନଥିବ ପରଦିନ
ଦେଖିବାକୁ